Yes, ma'am.
Must be some problem with joining. Good morning. You having difficulty? No. You joined? Yes. Okay. Okay. Now we can see you were just waiting. So we can start.
That is right.
Okay, great. Good morning, Mr.
Good
Sharma.
morning, sir.
Good to have you here.
How are you?
So that's Astha. He's the assistant professor and the coordinator.
So good to have you, sir.
Thank you for inviting me.
Good morning, sir.
Good morning. How are you?
And
Good morning, sir.
that's Mr. Pratap Singh, our registrar.
Yes.
So, Rachna, do you want to start now so that we
Yes,
can
ma'am.
be on time?
A very good morning to everyone present here. On behalf of Maharashtra National Law University Mumbai, ASA, and the Tech Forum, we welcome you all to the National Virtual Consultation Workshop on building a balanced framework for India's digital competition law. It's a privilege to have experts from legal, technological, and economic fields join us today to deliberate on this pivotal topic shaping India's digital market governance. Maharashtra National Law University, Mumbai, established in the year 2014, is one of the premier national law universities in India. Honorable Chief Justice of India, Justice Bhushan Ramakrishna Gavai, is the Chancellor of our university who not only guides us but also inspires the institution with his novel ideas and rich experience in the field of law. Our Vice Chancellor, Professor Dilip Uke, is a renowned academician in law with varied experience in teaching and research and is our luminary. Our pillar, our registrar, Dr. Pratap Singh Salunke, supports us through his vast network, resources, and administrative legal practice experience. To begin the program, I extend a very warm welcome to the dignitaries present with us today. We are honored to have our chief guest as Honorable Mr. Justice Anish Dayal, Judge of the Delhi High Court, our guest of honor Professor Giorgio Monti from Tilburg Law School, and our keynote speaker Mr. Sharad Sharma. I also welcome all the esteemed panelists, stakeholders, special invitees, students present for this event. It is a privilege to call upon Dr. Pratap Singh Salunke, our esteemed registrar in charge at MNLU Mumbai, to begin our session with a welcome address.
Thank you. Thank you, Rachna. At the outset, a very good morning to all of you. And indeed, it is a matter of pleasure to welcome all the dignitaries on the board. Honorable Justice Anish Dayal, sir, Judge, Delhi High Court, Professor Giorgio Monti, Professor of Competition Law, Tilburg Institute of Netherlands, Sharad Sharma, sir, co-founder of iSpirit, Ms. Anupam Sanghi, ma'am, founder and managing partner of Anupam Sanghi Associates and TechReg Forum. I also congratulate and welcome Dr. Vijay Kumar Singh, sir, all other panelists and expert global panelists for these sessions. I also congratulate Astha Tiwari ma'am for having this kind of initiative, because few years back in European Union, there was an exemplary fine which was imposed on Google for the anti-competitive practice which was followed, because when we used to search, then there were certain considerations which were taken into account, and because of which the initial hits in which certain companies and their names which were flashing, and that was not known to the people who were using the Google. And this was considered as a kind of an anti-competitive practice because platform needs to be neutral. And that is what is the essence of this particular national virtual consultation workshop, though it is happening in the phasal manner. At a later stage, definitely we will be able to provide the consultancy and the feedback for having a very robust law which will deal with the mechanism, because the it is really very difficult to deal with the situation as a reactive mode. And that's why law is required to be proactive, so that less intervention on part of the legal system, that is what which is required. So a digital competition bill 2024, which is also there for our reference and deliberation and churning, and which is also going to help us in future course. So on behalf of Maharashtra National Law University, Mumbai, also on behalf of our Chancellor, Chief Justice of India, Honorable Justice Bhushan Gavai sir, our Pro-Chancellor, Chief Justice of Bombay High Court, Alok Aradhe sir, our Vice Chancellor, Professor Dr. Dilip Uke sir, our Executive Council, Academic Council, General Council, all the members of the Maharashtra National Law University, all the members who joined us as a patron, co-patron for this particular virtual workshop. I really thank them from bottom of my heart. I welcome all the dignitaries for this particular national virtual consultation workshop. And before I conclude, it is very well said, law should be like a walking stick. It should always remain one step ahead. This workshop is an attempt to maintain ourselves and to trigger our own thought process in a direction so that one will remain one step ahead, so that we will not follow the happenings, but we will be very proactive and we will be able to provide the mechanism to deal with the situation. So once again, I am thankful to all the guests, all the dignitaries, all the panelists, all the participants, and everyone who is associated in organization of this national virtual workshop. Thank you very much.
Thank you, sir, for your inspiring words. Due to some unforeseen exigencies, Professor Dilip Uke, the Vice Chancellor of Maharashtra National Law University, Mumbai, could not be with us today for the workshop. We sincerely regret this, but remain grateful for his continued support and guidance to this event. We are grateful to have the privilege of hearing from Honorable Mr. Justice Anish Dayal, a highly respected judge of the Delhi High Court. Known for his sharp legal acumen and deep understanding of civil, constitutional, and commercial law, Justice Dayal brings a balanced and insightful perspective to his judgments. It is my privilege to warmly welcome Honorable Mr. Justice Anish Dayal for the Chief Guest Address.
Thank you so much. Am I supposed to go now or later in the schedule?
Actually, Rachna, Justice Ali,
I'm happy to talk now.
Justice depends on Mr. Sharad Sharma. Will you get delayed, Mr. Sharma? Because Justice Anish Dayal was to speak after you.
No, I'm okay.
You're okay. Okay.
I will be honored to listen
Mr.
to
Sharma clearly
him.
has a
Yeah.
more meaty keynote address. Okay, fine. I guess I'll overtake right now and just put a few thoughts together. So first of all, thank you, all of you, for having me, be as part of this inaugural session, and all the best for this consultation that you have decided. It's fantastic to read some of the sessions, the content of the sessions that is going to be discussed. I presume the students are also connected to this event in the morning. So all the best to the students as well and the faculty members. I had an occasion to come to MNLU long time back in Powai. Is that right? In Powai, and I was that time also, I think, delivered some lecture on IT related issues. So that seems that's a portion of my interest. Although as a judge we do everything else in everything. But anyway, just leave the experts to discuss the sessions. But congratulations on choosing Anupam and others. Brilliant topic, because we are looking at obviously this is in the backdrop of the draft bill which came through and now which has been junked for the time being, which has its own interesting implications, that there was something floated and it has got junked. So maybe in your sessions you need to also examine possibly the reasons why the executive did not go ahead with proposing that bill further. And that's we don't know the reasons for it, but I'm sure there's a discussion around it, and the experts would probably know. And that, I think, in that gap is possibly where my thinking lies, is that we are on the anvil of a very big upheaval because of artificial intelligence. I know AI is the big jargon, but it's far more than jargon now. And we are in that situation where AI is going to be upsetting not only the digital markets, but it's going to be creating its own space. So interestingly, if you look at it from an interesting macro perspective, we as human beings are actually creating our own competition. We have created our own competition. And what we are creating is possibly finally going to overtake us, dominate us. See, there are two views on this, and that's always a potential macro discussion, that will AI take us over, will AI not take us over? I'm going to give you a few pointers, which I happened to read in a very recent issue of The Economist, which is called The Economics of Superintelligence. It's a very interesting research study on various aspects of the new concept of superintelligence. Now, what is superintelligence? This is what the creators are talking about, is more than AI right now. They're talking about AGI, which is artificial general intelligence. Now, what is artificial general intelligence, which is also being called as superintelligence? Now, an artificial general intelligence is an intelligence which is potentially replace a human being at the workplace. So currently what we are using is, at our consumer level, we are using AI as a tool, or at best AI is being used as an intelligent algorithm for all your intermediaries, for all your data collectors, aggregators, which form part of your digital competition issue. Superintelligence is what is now defined as something which the humans cannot understand. It will be beyond our understanding. So that's what's called superintelligence. I'm trying to introduce these concepts because they're new to me as well. So each time you read something, it is very fascinating. And that's why I'm sharing it. Interestingly, there's this thinker called Nick Bostrom. Some of you might have read about him, and he has a book called Superintelligence, and he coined the word of superintelligence. He created this thought experiment, which is, I find it very fascinating. It's called the paperclip maximizer. Now, what does that mean? If you know about it, it might be repetition. I mean, it might be not news to you. But Nick Bostrom stated that if I give a super intelligent AI a goal, which is make as many paper clips as possible, quote unquote, make as many paper clips as possible, it would seem harmless. Then a thought experiment took him to a point where potentially what the AI will do will convert all available matter in the world to paper clips. it will take control of all global resources because it has to create those paperclips, the maximum possible paperclips. And it would resist a shutdown because that would interfere with its goal. That's another aspect of AI, that AIs have started now to resist their own shutdown. And it would colonize more space to create more paperclips. So it might sound absurd, but it's a very interesting and a very well-recognized thought experiment in the AI world, that it also exemplifies the kind of dangers that are before us. Now, what are those dangers? Some of the dangers that we have looked at is what the thought experiment looks at is something called misalignment. That you put in a harmless question, but it is misaligned to what the human wants. Then the issues of mistake. So these are dangers which we'll be faced with when we are dealing with super intelligence AI. And this is not round the corner. It's actually staring us in our face. If you read the literature, it's literally in our face. Look at the examples of what AI is doing. The reason I'm concentrating on AI, I'll tell you in a moment. But the reason is that I was just picking 3 examples. Today, the gold medal in a international maths Olympiad is being won by AI. Today, most of the new pharma patents are AI generated. The top models of AI by 2027 will be as capable as a programmer in an artificial intelligence lab. And moreover, which is the second layer, is that AI is going to be overseen by AI. A second layer of AI is being created by the top innovators today to regulate AI by AI. These are points of thinking and discussion. I'm not an expert. So the race for dominance in the AI world is so fast and so pacey that regulation and law is going to be left far behind. And today what we have as pointers are what I call pauses in the panic. These are pauses in the panic which is there in the world today. It's so fast. The creation is so fast. So today we are looking at a world where regulation, effective regulation, may also come through AI, of the AI. Now it's a bootstrap argument. It's an interesting point. I mean, there are things to think about. Now, how are markets going to get affected? Since your discussion is about digital markets, how are the markets going to get affected? One immediate scenario is of the labor market, of which there's a lot of discussion about, that the labor market is going to get completely overhauled. Because for an employer, why would you choose to pay a worker more than its digital competitor? A human being now has a digital competitor. We are very close to having fully perfect digital competitors. So that's another aspect where markets, traditional markets, labor markets, will be affected. The second point which struck me was that today when we were discussing the competition bill in context of intermediaries and OTT platforms like Meta, etc. But what is going to happen now, if AI is going to be giving you all the service, then who's going to control that market? The person who is controlling the AI capital. So the new way of looking at it is that you're looking at a world where not those who are owning the OTT platforms, and not those who are owning a social media platform, but those who own the AI resource and the AI capital are going to be dominant cross borders. So we are looking at the next wave, and that I think has to form an important part of your discussion in your sessions. The what happens to the legal and regulatory response? Now, that is again some things that you will thrash out and discuss, but you will be looking at more and more cross-border applications. Today, the digital competition bill draft looked at digital ecosystems in what are being serviced and offered in India. But you, with the AI algorithm and increasingly an AI service mechanism backing it, you might be looking at a very different challenge. So competition law, which forms the basis of your discussion, is meant to do what? Ultimately, it is meant to stop an abuse of dominant position. It is meant in a consumer interest. That's the whole idea. The whole idea of competition law, otherwise it won't exist. The whole idea is that, listen, you don't let somebody dominate a market, in simple terms, through various issues like combinations, etc., etc. But I have a feeling that, subject to, of course, the experts discussing it, that this draft bill has been withdrawn, possibly because there's inadequate research for us to move ahead. There's no point having a legislation which is only looking at the next 5 years. It's important in 2025 to have a legislation which is looking at least the next 10, 15 years. And maybe how AI dominant systems have been dealt with in the legislation is an issue. So may I leave? I'll close my address with that thought that please, in your discussions for the students and everybody else, it may be great areas to explore for this purpose, and may have very, very critical context in what is being discussed. So I hope I have not overshot the time that I had, and thank you, Mr. Sharma, in particular, for letting me lead. But I also have a engagement which I have to leave for. But I'll wait and listen to your address because I'm keen on that. Thank you so much.
Thank you so much for your enlightening note. Following this, I'm honored to welcome our keynote speaker, Mr. Sharad Sharma, the co-founder of the eSpirit Foundation. He has been a driving force behind some of India's most important digital public initiatives like India Stack. He is also a member of the UN's High-Level Advisory Board on AI and also serves on the India's National Startup Advisory Council and SEBI's Financial and Regulatory Technology Committee. With years of experience in leadership roles at global tech companies, Mr. Sharma now plays a key role in shaping India's software product ecosystem and technology policies. I now invite Mr. Sharad Sharma to share his insights with us.
Thank you so much. And Justice Dayal, thank you for your kind words. I feel the pressure that you are listening in. So I'll try and be brief, and would love interaction through Q&A later, if that makes sense. I have a few points to make. The first is that there is something special happening in the digital world in India. So let me put this in perspective. India is roughly about 3% of global trade. It is about 7 to 8% of the global economy. It is about 17.5% of the global population. But believe it or not, in the last few years, India has become more than 50% of the global digital transactions. Right? Now, this is important. I mean, we, of course, appreciate commerce type transactions because of UPI, and they are, of course, more than 50% of the commerce transactions in the world. But there are two other transactions that are worth paying attention to. And the first one of the two is DBT transactions. India accounts for 72% of the DBT transactions of the world. So if you look at India as a collection of 300 million families, the poorest 100 million families, they rely on government benefits and the revamp that has taken place because of DBT. And we as a country lead the world. 72% of the DBT transactions of the world, happen here in India. And that provides social, balance. If this was not happening, you wouldn't have you won't have the social balance that you have today. Second is that DBT is nothing but taking your and my taxes and redistributing them. India accounts for 54% of the tax-paying transactions of the world. Just imagine that. And that happens because of GST. And as you know, GST has had enormous tax buoyancy over the years. And the reason for this is that unlike any other country in the world, we collect GST not based on monthly business done between you and me, but based on the invoices and in fact line item of those invoices. And this is only possible to scale in a digital system. We didn't get it right in the beginning, but eventually we got this right, and that has resulted in enormous tax buoyancy. Now, so therefore, people all over the world are looking in astonishment to India, because when you cross 50% of the global transactions, and just put this in perspective, you can take China, Korea, all of Middle East, all of Europe, all of US, everybody else in the world, when they look at it and they say, hey, all these types of transactions, something is happening in India, which is resulting for this disproportionate share that is there in India. Now, why is this the case? There are two reasons for this. One is that the technology architecture is very different. As you know, the internet, what is internet? We are using internet to talk to each other. Internet has flow of packets, and flow of packets happens through a system called TCP/IP, a protocol through TCP/IP. Second is we set this up using email. That happens through another system called SMTP. I'm not going to simple message transfer protocol. Third is that we have web content sharing, and we are currently in Zoom using another protocol called session initiation protocol. All of these, they have only one purpose, that in this flow of packets, flow of messages, flow of content, flow of voice and multimedia content, there should not be a toll collector in the middle. There is no toll collector in the middle. So what happened in 2012 is that India said to itself that if we really want digital transactions to happen, which is that somebody wants to book a railway ticket, as an example, they will have to share their identity. So if I'm booking a railway ticket, railway is going to check whether I'm indeed Sharad who's traveling on that ticket when I board the train or board the plane. Second, I'll have to give some personal information to identify the train that I want to travel. And then, of course, I'll have to make a payment. And in this flow of people, flow of money and flow of information, we had toll collectors in all the three areas. And India, as part of India Stack, decided, can we create a system that will not have these toll collectors? And by creating a system where in the flow of people, money, and information, we don't have toll collectors, we have managed to unlock innovation, both in the private sector and in the public sector, at a scale that has never been seen before. So the tech architecture of the Indian digital system is unique. And however, this will not remain unique because our flow of people, for example, was rebuilt, because Aadhaar was built in 2009. It was completely rebuilt in 2018. It is called MOSIP. And today, as you know, this is parked in IIIT Bangalore. It's available for free to the rest of the world. And 27 countries use it. If somebody wants to go to mosip.io, you will see a live dashboard. Since this morning, 138 citizens of other countries have used our system. This is scale, right? I mean, this is our largest contribution to the world. Now, so first, there is a technology architecture that is there. The second is that, I took a flight recently. Let's say I'm normally based in Bangalore, but I took a flight from Mumbai to Bangalore, right? And so I entered the Mumbai airport using DigiYatra. Then I was hungry. I had some snack there and I paid for it by UPI. Then I landed in Bangalore and I took a Uber and paid for it by UPI. Possible, isn't it? Now I have two UPI back-to-back transactions, one in Mumbai and one in Bangalore. Now the question to ask is, does NPCI know that I'm now in Bangalore and I was in Mumbai earlier? Most of our listeners would say yes. And the actual answer to that is no. Because UPI as a protocol has no provision for sending location and merchant code to NPCI at all. And if you were to change this protocol, hundreds of companies will have to make that change. It cannot be done in secret. There'll be a hue and cry. And so there is a protection built in, because the technology, the public technology that UPI is built on, has built into it privacy by design that cannot be overridden by a bureaucrat or a policymaker. Second, I ask a question. I paid by UPI, which means it debited a bank account. That bank account, I opened, let's say, using Aadhaar, and I opened 2 other bank accounts using Aadhaar. Can somebody in the government of India, in Ministry of Finance or in RBI, put in my Aadhaar number and see all the 3 bank accounts appear there on their dashboard? The answer to that is no. Because it is illegal, as you know, under the amended Aadhaar Act after the famous Supreme Court judgment of September 2018. It is illegal to tie my bank account number with the Aadhaar number. What is more, when I do an Aadhaar authentication, I get only a virtual code. I don't get an Aadhaar number, and therefore it's not technologically possible. It is not allowed under law to make it possible. If I now take Digi Yatra, can the government of India go to my Digi Yatra system and say, what are the flights Sharad has taken the last 6 months? The answer is no. And you can humor me. If you just take your SIM out from the phone and put it back in, you will see all your history of Digi Yatra has disappeared, because it is stored only in your wallet. And there is no API that exists for the government of India to ask my wallet on my phone for all the flights that I've taken on Digi Yatra and all the old data. There's no central store of this at all. So why am I pointing this out, and why India is getting really this traction in the world is not only because we have quantity, which we have transactions, but we have protections built into the system. They come from a kind of a concept that is now being talked about. India's contribution to the lexicon is called techno-legal regulation. Now, what does techno-legal regulation mean? Techno-legal regulation means that if you want to shape the behavior of the market, you need 2 hands to do it. Think of it like a potter's wheel. Potter's wheel, you want to shape the clay, you can't do it one hand with hand. You need both the hands to do it. What are the 2 hands? Traditionally, the hand was policy and law and policy. But in the new thinking, it is actually public technology. So in India's view of the world, when public technology and public policy work in tandem with each other, we can shape market behavior in a way that we cannot do it if we were to use only one of them as we go forward. I often ask in a meeting, and because Honorable Justice Dayal is here, people will not answer truthfully. But if you go and ask people in a room and say, how many of you have a driving license without appearing for a driving test? You can go anywhere in India, 30 or more % of the hands will go up. And they are not even shy. They proudly will raise that hand and say, Arey, I got it. So in India, making rules and law is no guarantee of actually behavior changing on the ground. So this is why India's thinking of techno-legal, public tech and public policy becomes a very powerful idea. Now, not just for India, it is an idea that is important to the West as well. And I will give you an example. Because West used to be a very homogeneous society, so societal norms worked. So if you went to a CVS in the US and you bought a bottle of Tylenol and you came back and opened the Tylenol bottle, had one Tylenol and went back and returned it, they would take it back without questions. But this was being exploited to such an extent. Now CVS has this return policy by zip codes. So they keep the old return policy in a few zip codes, but in majority of the zip codes, they don't have that policy anymore. Because people don't follow it. The social norms have broken down. Right? So they are also coming to a point that legal compliance is no longer a way. You need techno-legal systems. So the first point that I want to make is that this idea is why DPDP Act is the third incarnation of that same act. The first act that Justice Sri Krishna made, 280 plus pages, was not cognizant of this techno-legal idea. It was meant to be, but somehow in the drafting committee, that idea got lost, right? So when it went to the JPC, some young MPs took a lot of interest, and a fairly significantly revised draft act came from there, right, which JPC approved. Now, it so happened that some of those significant young MPs, first-time MPs, one day, lo and behold, becomes the cabinet minister of IT and says, I know this even 180-page act is not what we are looking for. Can we do it in 35 pages? Today, that act is 35 pages, not a single proviso. It has examples in it. It's a model act. It is the first act written in the female gender. It's easy to understand. It's based on principles. So what in India slowly that is happening is that we are waking up to this idea that if you have to shape market behavior, if we have to manage this, we need a techno-legal approach. So what's the DPDP Act's public technology? The public technology is called DEPA, Data Empowerment and Protection Architecture. Now pay attention to this word for a minute because it has relevance to AI. Because anything that you want to do in the ecosystem needs innovation in India, because then only will it touch all Indians. And it needs protection. So it has empowerment and protection built into that public technology, because the public technology has two masters. One master is the regulator who wants to make sure good things happen. The second is a master is the innovator who wants to innovate so that they can serve this complex country called India. So public technology has to be built to allow for that to happen. So the question now that comes is Digital Competition Act. And this Digital Competition Act is about regulating digital monopolies so that we are not going to become a colony again, a digital or an AI colony again, something that Justice Dayal was alluding to as we go forward. Now, if we have to do that, we have to build our own ecosystem. Just doing copycat companies is not going to be enough. If there is a battle between Flipkart and Amazon, Amazon will win because Flipkart is a copy of Amazon. We will win because UPI is not a copy of Visa, MasterCard, WeChat, and Alipay. It is a next generation system which looks and feels different completely compared to all those systems. So therefore, we can build our own players in that area. So when it comes to AI, we will have to create our own version of digital systems. And that version of digital systems must therefore rely on building blocks, public tech, and should rely on principles. The principles are laid down in something that India offers to the world called DPI Sutras. There are 5 sutras. Why sutras? Because I'm sure many of you are yoga practitioners. You know that yoga is not those 84 asana alone. They are also Yoga Sutra. If you want full benefit of yoga, then you need to embrace asana and the sutra. Similarly, if you want the full benefit of the digital ecosystem, you need the asana. Asanas are the Digi, Yatra, are the Aadhaar, are the UPI. But the principles that underlie them are very important. What are those principles? Citizen agency is number 1. Number 2, privacy must be built in as design, because Puttaswamy judgment says privacy is a fundamental right. One of the first countries in the world to make an emphatic judgment or a statement like this in a 9-0 judgment, and a beautifully written judgment that you see that came out in 2017. Third is that we must not allow monopolies to happen. Fourth is that we must make sure we do techno-legal regulation. Fifth, if we offer this technology to anybody else, it should not be weaponizable by India. This is why MOSIP is in 27 countries. Our EVM machines are not in 27 countries, because the confidence that our EVM machines, India will not weaponize against another country does not exist today, because there's no techno-legal regulation of EVM machines. You know, something that Justice Dayal pointed out, that AI will be needed to regulate AI. So you need technology to regulate the EVM machines. Without that, if you're only going to rely on one hand, it is not going to create the trust necessary. So although Bangladesh took our EVM machines in 2017, only country to sign an agreement with election commission to do it, but never deployed, because there was a hue and cry back in Bangladesh when they went back and announced it there, saying we don't trust that there's no backdoor that India will exploit when this happens. So if you want trust at the citizen level, at another, there has to be non-weaponizability. These are the 5 sutras that we have. Now, the question is that if this is our thinking, what is the new Digital Competition Act that we need? I think the first Digital Competition Act was as broken as the original Justice Sri Krishna draft, because it was a copycat of what the Europeans are doing. And I am telling you, when some of you know this, when the European team came and all the team came, for the recent discussion that happened in February, what did they do? They spend enormous amount of time learning from India. I frankly, hosted Henna Virkunen, who is the commissioner for tech sovereignty and the digital regulation. I hosted a dinner because she spent a lot of time understanding the India model. I hosted a lunch for Robert Weiler, DG Connect, who is the regulator for all of this, because they are learning from India. So what is this funny thing that is happening is that the Europeans have woken up that they are in an archaic system and they need to learn from India. But somehow we in India haven't embraced this idea for our own thinking at all. We are copying their old ideas, which to them are no longer credible. And they want to copy the Indian system. We are not willing to apply our own Indian learnings for these new areas that we are talking about. So take AI regulation. There is a subcommittee for AI regulation, which has given its report. It is in the public domain. I bring it up because Justice Dayal talked about it. We have a concept that we'll treat it as a complex adaptive system, and we will have the ability to intervene anywhere in the system, because we are going to create a new type of a regulatory framework, which is techno-legal in nature, called an AI chain. Because AI, when you have a video which is a fake video, the fake video has been generated on a model. That model has been trained on data. That data has come from somebody's personal data. There's a whole chain here. And if we can track this chain for the sake of the regulator, it becomes very easy for us to intervene. Why is this important? Because we have to worry about our children. We last year had 23 million babies that were born in India. China is number 2. China's number of babies were only 9 million. Nigeria is number 3 at 8 million. In fact, if you take the next 5 countries, they are roughly 23 million. We are the cradle for humanity in the world. We have 300 million people who are under 15. And AI, while it will lift the performance of some of those children, as you can see happening in chess, we have the largest number of chess grandmasters, 89. All of them are young. The youngest chess grandmaster is Indian, because they're learning from AI. They're not learning from human coaches, because we haven't created enough human coaches who can train grandmasters. They are learning from AI to become grandmasters. On the other side, we are losing children because AI pornography, AI gambling, and AI AI gaming is going to destroy the lives of our children. And if we have a lost generation in India, the human race has a lost generation. So we have to regulate child safety in a model, a democracy like India, using techno-legal regulation. The obligation for us to do this is more significant than for any other country in the world. And we cannot follow the European model to make it happen, for heaven's sake. We have to invent our own Indian model to make it happen. So avoiding colonization, dealing with our own problems of child safety, letting innovation happen at a scale, so that what has happened in chess brings out the best potential of every child in every area that we are talking about. On the back of Indian AI are enormous challenges before us. So when we look at Digital Competition Act, it has to be seen in this framework. We have to invent it based on our needs, not by copy pasting something that has happened in Europe. So please, I implore you to not be a copycat of what the European model is. It is not a good model. It is not considered as the gold standard by them. They are turning to us to learn about what they should do next. It is a failure. And we have the ability to develop our self-confidence and say we can do better, provided we think from first principles and make it happen. And I think we will make it happen, thanks to the wonderful learnings that are there, both in our strong legal community and in our public tech community that we have here in India. I may have taken longer than expected, so my apologies.
Thank you, Mr. Sharma, for your enlightening keynote. We are privileged to have Professor Giorgio Monti as our guest of honor, who's currently a professor of competition law from the Tilburg University in Netherlands. But due to the time differences, he kindly requested us to let him join post lunch. So he will be addressing us at around 1:15, and we eagerly look forward to hearing his thoughts. I'd now like to call upon Asta Tiwari ma'am to give us a vote of thanks so that we may move on to our first session.
Excuse me, Asta, we have some 5-10 minutes. If there are any questions for either Justice Dayal or Mr. Sharad Sharma, I think we can have 5-10 minutes. Is that okay?
Yes, ma'am, we have time. We can definitely do that.
Can I have the first comment? I
Yes.
think I have been fortunate to hear Mr. Sharma in the last 15 minutes. It's been, and I've taken down detailed notes. It's the how you see the whole perspective from the top down is fascinating. And I'm a great believer in indigenous creation, particularly now on the legal side, because been borrowing for years, for centuries, from our colonial systems, which have not served us well, frankly, in so many areas of law. And wherever innovation, and the DPDB Act, according to me, is a great innovation. Let's see, and hopefully it'll get enforced, and hopefully it'll force out. And you are absolutely right. And this whole construct of a techno-legal construct is so critical. I think we have also sort of been, from the legal side, have been talking about it. I said the drafters, Mr. Sharma, are not equipped. The traditional legal legislation drafter is not equipped simply to deal with situations that we have to deal with, that we are facing. So a beautiful construct, and I'm going to look all this up to educate myself a bit more. And yes, Yoga Sutras are extremely important for understanding existentialist issues. And rightly said, the physical aspects of yoga are only part of it. And that's a great metaphor to use for this stretch. So congratulations and thank you.
Thank you so much.
May I ask one question? I have a question for Mr. Sharma. And on a lighter note, if we can put the judge in the witness box, what do you have to say about the dangers that he mentioned about AGI?
No, very significant. See, because, look, if you go back in time, and I'm going to fully agree with what Justice Dayal is saying. The way I think of it is that if you go back to 1300s, a Renaissance, Leonardo da Vinci, Florence happened. That made the popes very powerful. And, that led to bad behavior. It was called the age of indulgence, right? They had all kinds of problems going on with the popes at that time. So later, when the printing machine happened in middle Germany near Frankfurt, remember that led to people rebelling against the Catholic religion at that time. And the only way they would protest is to tear a page of the Bible and post it on the church, because the Christianity of the Bible was completely out of sync of the Christianity that was being practiced at that time. It didn't need anything more to be said, right? And then this revolution moved on, and in Germany, you had enormous polarization that happened because every town, city, state became Protestant and Catholics, and they were literally killing each other. This is like our polarization in the left and the right. And then they came because of medicinal baths, as you know, in Northern Europe, and a place called Baden-Baden, where for medicinal purposes, the families would go for medicinal baths because they wanted to purify themselves. So everybody, father, mother, daughter, son, everybody would strip naked for those. And so then to make that happen, because if you didn't do it and one person of the family didn't go, the benefit of medicinal bath was not fully achieved. So therefore, they decouple nudity from sexuality. And they said, why can't we decouple religion from state? So believe it or not, that idea originated in Central Europe and was formalized in the French Revolution. And then the story moves to UK because of James Watt and the Industrial Revolution that happened because of the scientific revolution there. And that resulted in brawn going away and children being employed in the factories. And Karl Marx in Germany writing in 1848, the manifesto to protest against this, right? And an alternate worldview emerged and says, hey, communism is not the answer, Marxism is not the answer. And an age of enlightenment emerged in Europe, which is what we live in today, that everybody has a right to education. A peasant and a feudal lord's child has the same right to education. Crime and punishment was reimagined, and what we describe as enlightenment today. This is a 500-year journey. This 500-year journey is upon us again, driven by AI. So the societal change, how we work, how we regulate, how we do think of crime and punishment, all of this is up for change. Unfortunately, it will not happen in 500 years, it will happen in 50 years. And I think this gives us a chance. It will redefine, like Age of Enlightenment redefined what it means to be human. Human was not a brawny guy. Human was now a skilled person, right? And so now it will redefine what it means to be human. My belief is that this is where India ought to thrive if we can embrace this, because our definition of humanity is inward looking, is about it is very different from the Western notion of what it means to be human, what it means to have a good life. And I think our Eastern, not just Indian, but also other Eastern cultures, but India predominantly, has a definition of what it means to be a good human that will become more important in the world of AI than has been the case in the world of the traditional industrial revolution. And therefore, we have an obligation to all work together. The public technologists, the legal profession, the educators, we all have to come together in India to take charge of this, to redefine and expose our thinking to our own country and to the rest of the world. So I see it as an opportunity for us to redefine our society so that a better society emerges. That is our challenge. Now, will we do it? Time will tell, but I feel cautiously optimistic that we can.
Thank you. That's indeed really profound. Didn't expect such a profound answer to this technology-related question. And I think we really need to, after we have read, and I would even, request Justice Dayal to read. I've read the DEPA framework. It's pretty fascinating, and for legislation, this can be very, very useful. So I would also request the students to read that framework and maybe invite Mr. Sharma on another day for for a longer discussion on that.
Details of DEPA are on depa.world. It's on a website. It's all in the public domain. And Government of India is going to release a 41-page document to further kind of as an educative document, I think, in the next 2-3 weeks. So I would love to. I really feel our human society or Indian society, we have to work across boundaries to deal with this new change that we have. So although if you talk to a 10-year older version of me, I would have lived only amongst the techies. But I am now a convert that we have to find a way to work together.
Thank you so much. Over to you, Astha.
Thank you so much, everyone, respected dignitaries, esteemed guests, faculty members, students. On the behalf of Maharashtra National Law University, I extend my heartfelt gratitude to everyone present here. Especially, we are deeply honored to have you, sir, Justice Dayal, sir, for bringing out the importance of AI and how it is a double-edged sword. We are so grateful to Sharat sir for your insights. It's the need of the hour to have techno-legal framework and how public technology and public policy has to go hand in hand. So thank you so much for bringing that up. We are also grateful to our registrar for his warm welcome. And a special mention to our Vice Chancellor, Sir, Professor Dr. Dilip Uke. Though he could not join us today, but his vision and encouragement has always been a part of this foundation and the initiative that we are taking. Finally, I thank everyone who's present here. It was a wonderful and quite a thought-provoking session, and I can't wait to be a part of subsequent sessions also. Thank you so much. A special thank you to our chief guest, Justice Anish Dayal, sir, for being here and enlightening us on the use of technology. And Sharat sir, thank you so much once again.
Moving on to our first session, the dialogue on the role and evidentiary value of data in digital competition regulation. It is our honor and privilege to have Ms. Anupam Sanghi, the founder of TechRec Forum, co-patron of today's event, and a leading TMT lawyer who brings over 2 decades of experience in technology law, to moderate this session. Our esteemed panel includes Dr. Lalit Bhasin, the managing partner of Bhasin & Co., president of the Society of Indian Law Firms, and a veteran legal practitioner with over 6 decades of experience in corporate, constitutional, and labor law. Dr. Gauri is a former member of economics of the Competition Commission of India and an accomplished economist with 15 years of experience in regulatory economics and competition reforms. Dr. Kumar serves as an additional secretary in the Ministry of Law and Justice and is renowned for his strategic leadership in legislative and regulatory frameworks. He is also a recipient of the prestigious Atal Samman. Dr. Singh is a professor and dean at SRM University and a former deputy director at the Competition Commission of India with deep knowledge of competition law. Professor Pingali from IIM Ahmedabad is an authority in game theory and behavioral economics, bringing valuable perspectives on applying these fields to digital marketing regulation. I now call upon Ms. Anupam Sanghi to take over the session as the moderator.
Good morning, everyone, and thank you for joining this important consultation workshop on designing balanced frameworks for AI and digital market regulation, with a special focus on the upcoming Digital Competition Bill. Let me begin with an observation. Today, some of the most influential technology companies in the world are led by Indian origin CEOs. And senior executives, the people who sit in the C-suite, are like Satya Nadella at Microsoft, Sundar Pichai at Google, Arvind Krishna at IBM, Shantanu Narayan at Adobe, and many others who hold crucial C-suite positions across Silicon Valley and beyond. Now, this global leadership is a reflection of India's deep talent pool in technology, engineering, and innovation. And yet, when it comes to technology regulation, the same depth of expertise is not visible always. The frameworks we rely on often emerge from legal and economic perspectives, but not necessarily from the lived experience of building or scaling digital platforms, like we just heard Mr. Sharat Sharma, that how regulations or policy needs to be lived or needs to form part of people's lives. This creates a mindset gap between those who innovate and lead in the digital economy and those who design the guardrails of that economy. So the Digital Competition Bill gives us a unique opportunity to bridge this gap. The question before us is, how do we design regulatory frameworks that are balanced? ones that curb anti-competitive practices without stifling innovation, that protect consumers and smaller players without penalizing success, and that recognize India's ambition to be both a digital powerhouse and a global standard setter in the responsible AI governance. Today's workshop is not just about compliance, but also it's about co-creation. We are here to bring perspectives from law, economics, business, civil society, and above all, from technology itself, techno-legal solutions, to ask how can regulation keep pace with innovation? How do we ensure India is not just catching up with global regulatory trends, but setting benchmark of its own? With that framing, I invite all the esteemed dignitaries in this panel to share their expertise, challenge assumptions, and help us work towards a regulatory vision that is fair, forward looking, and firmly rooted in India's strength. So, may I first call upon Ms. Geeta Gauri, who's been the former member of the Competition Commission of India, to enlighten us about in this backdrop about digital competition bill. How do we move forward from here? What are the kind of frameworks we should look at, and what experience can we use and further evolve from here?
Am I seen?
Ma'am, you're not seen. The video is not on, but we can hear you.
How do I put on the video? Ooh. Is this the video? No, here, right. Just give me a hint.
It's on the left-hand side after the mic.
Yeah. Yes, start my video, right? But I'm still not coming on. Start my video. Is that fine?
Not yet. Would you like to go ahead like this if it's a problem? Maybe some permission is not granted, is it?
No, ma'am. I have requested you to switch on your camera. Can you see a request from the admin? From the co-host?
Where is the request? View.
Ask for start video. Are you getting any
The
request?
host has asked you to start your video, okay?
Yes.
Shall I say start my video?
Yes.
Oh, they don't want the regulator. This must be Vijay's work.
Dr. Vijay Singh, you're being blamed for this.
Nah, he's an old friend. I can say anything.
Geeta ma'am can say anything, so there is no problem at all. She has been our mentor, so it's perfectly all right.
We would love to see you, ma'am, but if it's really a problem, then we can probably go ahead like this.
No, but how do I get this? No. I've been thinking of
On the madam, on the left side, there is an audio and then video. You just click on that video, it will open automatically. Click once, it will open.
The
and
second
when you click
time.
second time, it closes.
Icon, the second icon from the left.
I've clicked once.
Yeah.
There's a red button that's come. Mirror my video. No, I should remove that, no?
No, ma'am.
Would you like to re-log in? Would you like to re-log in? Maybe that might help.
Yeah, I think I should do that. I'll re-log in, okay?
Yes, ma'am.
That means I have to close this completely. You know, I logged in to hear the other two speakers who were very interesting and to have my breakfast.
You can continue without a video if that is possible. In case if it is not getting settled right now. Anupam, you are on mute.
Ma'am, on the extreme right, there's a hexagon which says leave. you can leave and then come back again. And maybe we can start with Mr. Lalit Bhasin in the meantime. Mr. Bhasin, it'll be nice to hear about the role of lawyers, law firms, and in these areas of specialization. How do you reckon that we work towards specializing, or should we just carry on with there's so much in the general advisory and litigation work, which we also need to know. But then how do we really become specialists in this? And the students, how should they look at their career, sir?
Thank you, Anupam. I think it is wonderful to be participating in an event in which I do not have any expertise at all. But I am here to learn. And it was a very enriching experience for me to hear the views of Honorable Justice Anish Dayal and also Mr. Sharad Sharma. Very lucid, elaborate, and very relevant and topical so far as their observations, you see, are concerned. They spoke about the positives and perils of AI, the technology. And that is the dilemma which the present legal profession is facing. Facing in the sense that they want to adopt and adapt their practice, you see, to the latest developments in technology. At the same time, they are also aware of the hazards and the perils of AI being misused. And as Mr. Sharad Sharma rightly pointed out, that we may have a situation which is not just confined to legal profession, but to the younger generation, that we may face a situation of a lost generation if some positive steps are not taken in the field of introduction and promotion of artificial intelligence. My view is that artificial intelligence has to be used as a tool. It should not become our master. It can become a very unruly horse, you see, if it is not controlled or regulated. If not controlled or regulated, it can play havoc, you see, with the system of administration of justice as well as also in our law practice. You must have heard and read about various instances where some judgments you see delivered, not just in India, but even in overseas, have tried to use AI for being incorporated and in the judgments itself, and that proved disastrous, you see, because the judgments were totally unreliable, faulty, and without application of mind. You see, there is no substitute for the human brain. Therefore, so far as the practice of law is concerned, we have to use AI as a tool of research, tool of helping and all that. I remember the Honorable Chief Justice at that time, Justice Chandrachud. He and I were sharing, you see, a head table at Symbiosis Law School in Pune, where he said that these are the technological improvements we have made in the system of administration of justice, ease of filing cases, ease of filing affidavits, evidence, having even the virtual hearings all over the country. So when my turn came, I said, yes, your lordship is right. All these have played a very important and significant role. But what about the disposal of the matters? There are about 6 crore cases now which are pending all over the country. Our institutional regulators, they are also heavily burdened, you see, with backlog of cases, whether it is consumer protection, whether it is labor courts, you see, whether it is the competition commission, everywhere we see cases piling up. Therefore, ease of filing cases has in a way also resulted in piling up of the cases. That has to be controlled. So what is the way out? That is where you see artificial intelligence can be used to streamline some of the processes, but not to deliver judgments and all that, or to give written opinions, or to apply your mind to the agreements, the joint venture agreements, M&As, agreements which are, you see, part which will be scrutinized by the competition commission also. Therefore, there has to be application of human mind and not the use of artificial intelligence. Therefore, we have to be conscious of this techno-legal concept, as rightly pointed out by Justice Anish Dayal. We are all for that. And you mentioned about the specialization. Yes, this is an era of globalization. That means sitting in India, we must know what is happening, you see, in the contemporaneous laws, you see, in EU, in US, in Japan, in Africa, everywhere else. Therefore, specialization in commercial and business laws is very, very important for the economic development of our country also, because economic development can only happen with legal support. And the legal support which we have to give should be based on our expertise, on our experience. And that is where, as you rightly said, the specialization comes in. Now we are seeing the emergence of different law firms, lawyers who specialize in different branches of law. So that is very important. And I think in India, we are now having a brilliant think tank of expert lawyers, good law firms who are devoting their time and attention to the issues that arise. So that is for the time being. Thank you, Anupa.
Thank you. Wonderful to hear that, sir. And I'm sure the students feel inspired, that this inspired, and yet they have to work a lot on this, much more than we did, sir. I think there's a lot on their plate now. So now may I call upon Ms. Geeta Gauri, former CCI member. We look forward to hearing from her.
Why doesn't my photo come in video? Is that fine? Asta, is that fine?
Ma'am, your camera is off again. It started.
Okay.
But we still can't see you, ma'am.
I know, that's what I'm wondering why. My camera is so nasty, huh? Then just go on audio. Or
Yes.
it's come up?
No, ma'am, we still can't see you.
Yeah. Share more. Oh, start my video.
Now it shows that the video is on, but we see a black screen.
That's what I've noticed. I think we're just wasting a lot of time in getting my video. I suggest we just go ahead.
Yes, ma'am. Anupam ma'am, you are on mute. Geeta ma'am, I think we can go ahead with the audio.
Yes, ma'am, because I think some settings will have to be changed. So for now, I guess we'll have to miss seeing you, just hear you.
You can see me. Oh, very nice. That's enough.
No, I'm saying we'll have to miss seeing you, but just hear you because some.
Yeah, I think so. Let's not waste time, huh?
Yes, ma'am. Please go ahead. Yes, ma'am.
You know, and I did hear the earlier lectures, bits of it between going in and coming out. And I was very fascinated by the techno-legal aspects of it. And I was thinking about the Competition Commission itself. And in terms of the Competition Commission, usually the question happens with regard to the digital markets in India. Since they're marked by three features, these are the three features that will have to be considered. One is this is strong protectionist assertions of the government. Now, that also means that not in terms of what comes on the net, but in terms of the taxation process. This is a very strong protectionist policies. Then there's a lot of emphasis on emerging markets. You know, that has become a government policy. It's just not platform markets, but on platform markets, the question of data markets and market for ideas, that is patents. And in fact, in today's lecture, I would like to talk a lot more on the question of data markets and markets for ideas. And the fact that in the platform markets, the protectionist policy is always worried that it'll be the big five who come on and they'll take away the data. So let's look at what is the concerns and whether they can be handled or not. And the last one is, of course, the ex ante rules that have been made by the market. And we shall now look at it further. See, the Competition Commission was always an ex post. And now they have to take on the new role of being ex ante. And this makes it quite difficult for them because they must know what to control. No, I shouldn't say control, what to regulate. And what to regulate, as I said earlier, has a lot of the assertions of the government. What should be regulated and what should not be regulated. And surprisingly, although with the later competition policy, one did get a little tired of looking at analysis of only that if you're big, then you are anti-competitive or you are something that needs to be regulated. And in the question of the platform markets, many of the players are big. But if they are big, it doesn't mean that small players shouldn't come in. So what the commission has to look into is to make sure that there are no entry barriers that have been created by the big players. And there are one or two cases that we have had in terms of what could be the entry barriers to it. And the question is how to try and assess them. Does domination work? The old section 4 doesn't apply any longer. And in the new act, they have in the new law, which has yet to come into focus fully, they have looked at it, but somehow size is an obsession that the commission has always gone with. And the other important thing about some of the players on the internet is you have to scale up very quickly. If you don't scale up very quickly, there's every possibility of tipping over. And when you tip over, gone. So who can scale up very quickly? And here, perhaps some of the younger players from India are very good at it. They do scale up. I've had a chance to meet some of them. But having stated this as the basic arguments before the commission, what is it that I would like to look at it? First is this entire aspect. I'm not going to look into the moral aspect that children shouldn't come onto the internet and how do you regulate it and all. That's being taken care of and that's very well known and accepted. But what do you do about data access? See, the data access that the big players are able to get are extremely relevant. And this data is a question now. We have a completely new market called data markets. You know, among the earlier traditional markets and all, forget about all of them. There is now what is known as data markets. And in data markets, there's a lot of buying and selling of data. And this buying or selling of data, all the big companies have a separate group or a separate not organizations, let's say set a separate branch to look at the aspect of data. And we have a lot of data in this country. What is the kind of data that we have? You know, it's not just that they're interested in looking at personal data. There is this old lady talking and she's 70. That is important, true. This is something they would always try and see if they can do something about it. And when they have this data market going on, then the issue that becomes is that what is it that India gives? You know, we're such a diverse country. We have all kinds of illnesses. And who would like this sort of data? It would be a large proportion of pharmaceutical companies. They would really be interested in knowing what sort of illness is prevailing and how they can possibly utilize this data. But then, as I said, data is again very precious. And we've had a lot of surveys in this country. In fact, there was a separate discussion on among a few of us on what do you do with these surveys. There are surveys on, you know, not just normal surveys of looking at income, which is an important factor, but there have been a lot of surveys on age, on income, on facilities, and what are the illness prevailing in this country. This diverse country, I do not know about the larger continent called Africa, but in this small subcontinent, we have every type of illness that would be required. And there's a market which the pharmaceutical companies are looking at it. And what do the pharma companies are interested in? And what is it that the Competition Commission should do is how to regulate this sort of, or how to control this data selling. And data selling and regulation is a tough issue. You know, we don't have any background about it. We do not know if we'll land up regulating the wrong sort of data analysis that is taking place. And I think this data regulation is the most important concept that has to be discussed now. We have to find new ways of data regulation. And I do remember that when I was with the commission, Anupam did come up with some ideas. But then, you know, the commission is always slow to react because we're a commission. The important point one should remember about the Competition Commission is that we get a lot of information. We are not only getting information from the people who are presenting the case, we're getting information for people who are against the case, but we're also entitled to collect information from any source. That is a privilege that has been given to the Competition Commission. And in collecting the data also, it's very difficult because you see, we're back again to being ex ante. So should I just keep collecting data and putting it all in my files? Or should we keep it in some sort of a closed box? You know, that's not a privilege that's allowed for. And the approach that say, and I know Dr. Basin did speak about the European approach, you know, those are developed markets. They have a very different approach altogether in terms of what they would do with data and how they would handle it. But here we have a gold mine, a data gold mine. And data is the new oil, as people keep talking about. And how do we make sure we can use them and yet come up with regulations to try and get proper ex ante? See, this ex ante ex post, how do you deal with it? What did the government do? The government came up again with something which they said that when you're looking at digital markets, you must try and get what is known as systematically significant digital enterprises. That's the word that they use, SSDE. But here again, what is it? Systematically significant digital enterprises means that you're looking at big companies. You're looking at size. And once you start looking at size, you're again back to the ex post way of analysis and not the ex ante part of it. And to evolve an ex ante thing, you need to encourage all the growth issues that are coming up. And what do you need to encourage and how you will encourage? I think, as I said to you earlier, it's the measures that the government can take. It's the taxation measures that could be taken while you're trying to encourage, say, a youngster, say from IIT who's come up with a new idea, then what is to be done? This takes me to the next point, which is important on the question of the patent system. You know, the connection between this data collection and the patent system becomes extremely important, because once a patent is applied for with the data, then for 14 years you can't touch it. You have created a monopoly without realizing a monopoly that can be created. And this is what we found. If you may recollect, earlier they were thinking of having two separate commissions. You know, one, they wanted a commission for antitrust and another a commission for mergers, but that didn't go through, so they came together again. But the same issue has come up. Why not have a separate one for digital markets, which would be an ex-ante commission, and for the antitrust, which is ex post? Antitrust ex post, there's really nothing left on it. Everything is now ex ante, because what are we looking at? The government is looking at encouraging as much of investment to come in as possible. And they have come out with the concept of the green channel. Let investment come in. It doesn't matter if investments do come in. But once investments come in, then what happens to the question of patents? And this, I think, is an issue that has to be again examined very carefully, because these are patents which you can't buy one or two patents. You know, you buy them together, which is known as a SEP, or a standard essential patent. And the commission, when it comes to the commission, and they say, look, we've paid for it, we've bought it, and there's nothing that can be done. And there are two companies which are major ones which have come before the commission. One is Ericsson. I mean, Ericsson has been a little bit more open. And then there is Qualcomm. So what do you do when you buy all these patents? Here the commission will say, what are you going to do with so many patents? And how to handle patents? Slowly what is happening is that the patent commission and the competition commission are now more or less on level. And perhaps the patent commission gets an edge, because it gets the details of the patents, who has got these patents together, what are these patents, are they relevant or not? Now, the latter part, are they relevant or not, no commission can decide on it. While the competition commission is left really with a leftover ex post analysis when it is trying to be ex ante. Now, I have tried as quickly as possible to bring out all the major issues that are facing the commission. And some of these major issues that are coming before the commission, I think the data problem becomes important because of the Digital Protection Act. What data are they protecting? And in this data, there was a Digital Protection Personal Act, then there was an Information Technology Act. But I think it is this situation, perhaps it is best to let competition take place, let there be as many players as possible, so each one regulates the other. And that to happen, that is why I said, perhaps the Competition Commission role is now getting slightly more limited, although I've been a member for so long and I've been for it, but the role for an ex-ante player is there, but it goes back to being again an ex-post player. Look at me contradicting what I started with and coming back to the conclusion that perhaps what they thought of as a competition commission continues to exist even now. And maybe they will have the idea that you have two commissions may or may not work out because it doesn't have so much of relevance.
Thank you, ma'am. Really something to introspect and think about institutional design based on, you know, your insightful remarks and your insightful experience from what you shared. We also have Dr. Vijay Singh, who's been with the CCI back in those days and now is fully into academics as a dean of SRM University. We'd love to hear from you about how this whole evolution of the regulatory framework can or may pan out?
Thank you, Mr. Nupam, for inviting me, and MNLU, particularly Professor Astha. It is a pleasure to be part of this particular panel with erudite speakers like Dr. Lalit Bhasin. Thank you, sir, for your insight, input, and my former member, Ms. Geeta Gauri. And I see, Professor Vishwanath Pingli also there. So, whom we invited long time back. I don't know whether Professor Vishwanath remembers, on a pharmaceutical conference at CCI when I was there in the capacity building division. This particular topic is actually having a lot of dimensions, as we could witness from the speeches of Honorable Justice in the morning, as well as Mr. Sharma. Thank you for introducing me to Mr. Sharma, because he is, having so much of a knowledge in this area. He brought up a number of dimensions, particularly the techno-legal aspect of it. But in my talk, I would just like to focus upon the area which you have chosen for the workshop, that is balanced framework for India's digital competition law. So can this digital competition law only focus from a competition commission perspective, or it will include multiple stakeholders, is a question which we should ask. And towards this end, when I look at the framework, there are a few things which are very, very prominent. And we are talking about ex ante regulation, whether there should be ex ante regulation or not, and what implications it would have. So ex ante regulation is basically regulating markets before something bad has happened in that market, or you are trying to see that potentially some harm should not happen or consumer harm should not happen, and you are trying to have a look at it. This question on ex ante has always been, a tricky question, for a simple reason that whom to regulate, whom not to regulate. And this we have seen in case of combination regulations very much. When we wanted to make it more tighten, then there was a green channel which was introduced, because that you're too much of a tight mergers and amalgamation regulation does not promote the market or the foreign direct investment or the investment, or it is not conducive to the market players. And hence there will be always a talk on this front, whether to have the ex ante regulation or not have the ex ante regulation. What we have been, following is the international framework, which has been developing, particularly in European Union. And you can see the reflections of those legislations in our market, and regulators as well as academicians discussing that whether we can have this ex ante regulation in our markets also. And this has been triggered by a number of aspects, including the dominant players who have been working in the market, and their impact on the digital market, and particularly the indigenous player or small players who are coming up in the market, and whether there is an abuse of dominant position by these big players against the smaller players. So this is the broader question with which this all things have started. And then the concept of this systematically significant digital enterprise came up, and as appropriately pointed out by Geeta ma'am, that the dimension of measuring who should be this SSDE is a question, and a major question. And we are grappling with this situation. What would be the parameter to decide who are these SSDEs? Because that will be a decision which needs to be taken, whether this will be the Competition Commission of India or it will be a separate regulator altogether. So Digital Markets Act, if you look at it, or Digital Services Act in European Union, if you look at it, their primary purpose is to identify the gatekeepers. So they have made a regulation, or this whole regulation of Digital Markets Act or the digital competition law is that the bigger players should come voluntarily and declare that they are bigger players, and they should be announced as SSDE, or in European Union, you call them gatekeepers. And these gatekeepers will have an additional obligation to, follow as per the regulation. And they have to give certain declaration, and they have to behave in the market so that they are competitive in nature. Now, if we come back and see the Indian market, and a beautiful question was posed by Honorable Justice Dayal, is that what is the motivation for now shelving this particular law, right? And we are seeing a lot happening in the international market, particularly from the tariffs perspective, particularly from the bilateral agreement perspective. And international trade works on multiple platforms or multiple dimensions. And if you look at these relationship or geopolitical developments which is happening across the world, at present, it doesn't make sense to regulate the market, because once you have the regulation in place, it applies to all, including the indigenous players. And where now the international markets are talking about protectionist regimes everywhere, everybody is trying to protect their own market. Why we should have a legislation which is unnecessarily restrictive in nature at present? That is what may be the thought to park this particular legislation as of now. But I have a different take. When I saw this digital competition law bill or digital competition act, which was put in public domain, and I looked into it and had a look at it, and I find that this new law specifically as a separate legislation doesn't make sense. Because the existing legislation, which the Competition Act, which we are already having, is sufficient to deal with this situation. If you want a regulator, there is already a regulator in place. If you want this digital market to be regulated, you only need to define what are SSDE and put it across as one of the chapters in the Competition Act, and the same paraphernalia will work. Otherwise, what will happen is you need to have a complete different legislation and a complete system of regulation, and then a new jurisprudence has to be starting from a digital competition bill perspective, and there will be a lot of time which will go in setting up that jurisprudence. Particularly, if I look at the dynamics of competition market, it is not in the digital market. It is not a market which is very what you can say stagnant or which doesn't change. The nature of the digital market is that it is so fast changing. So you make a regulation today and probably tomorrow, after 2 years, it is not applicable to it. So it will be more of a sandboxes approach. You need to give window to these particular companies to operate and experiment and come up with new ideas, and too much of a restriction in the initial phase will be actually detrimental to the sector. This is what is my view overall. And it is not a situation that we have not dealt with in our regulatory space. If you would recollect, I draw your attention to Information Technology Intermediary Guidelines rules. That was, to 2021 rules wherein we came up with social media regulation. And where we defined this SSDE, ideally, if you look at it, there was a notification which is specifically said, and it was a notification under Information Technology Act. And it said specifically that who would be the significant social media intermediary. And there was a notification which said any intermediary who has 50 lakh registered users in India will be a threshold for social media intermediary to be considered as significant social media intermediary. This is what exactly is required in case of digital regulation of digital companies. And you already have a regulator, either it is the TRAI or it is the Competition Commission of India, whichever may be the regulator. It doesn't make much of a difference, and that can regulate this particular market. This is what is my primary view on this part. Now, coming in terms of the law, if you see, they have identified certain services which are called core digital services. And they have also identified the definition of a systematically significant digital enterprise. And there they have tried to give it by way of turnover and global merchandise value. This is what I can see from Section 3 of the Digital Competition Act. And this is what I had one major point to say. And in Section 4 and from Section 8 to 15, you can find the different, different practices which are prohibited, or the obligations on these bodies, particularly like anti-circumvention provisions, reporting compliance, fair and transparent dealing, self-preferencing, data usage, anti-steering, tying and bundling. All these particular elements have been mentioned, they have been defined. And probably these are nothing but an extension of Section 4 violations if you look at it. So it is just, the violations which are there in Section 4, you just add a clause in it and make it applicable to digital companies and define SSD in between. I believe these few changes can be brought up in the existing Competition Act, and that will serve the purpose rather than having completely a separate law, because when you have a separate law, its jurisprudence develops completely separately. This is one part of it. Second part is about having a person in the handle or a gear. Here, I would like to mention Dr. M.S. Sahu, who was the first chairperson of the Insolvency Bankruptcy Board of India. And I am very much fascinated by his approach and way of shaping up that particular body as the first chairperson of IBBI. And the way you see the regulator has been shaped up and brought up is quite commendable. And we want someone like him, in this. If you want a change, then you need to have a driving force who will take it forward. So that will be a very, very crucial step if government chooses someone who will be looking at this dimension of regulation of digital space, must be having understanding of digital space, must be understanding about the digital markets, and they should be taking charge of managing this, and then only it can function. So these are my comments, few of them, and going forward, I am open to any questions, and then we can have further interactions. Thank you for giving this opportunity.
Great to hear you, Mr. Vijay Singh. You definitely brought in, a perspective which the students would love to research about, questioning the digital competition bill and moving forward, what can be the roadblocks. So therefore, a lot to think and research about. Now, can we go to our very, very favorite and deeply academically researched person, Professor Vishwanath Pingali, who's also recently published a report on Apple. So really looking forward to your views, your insights, and how can we move forward? How should we evolve the regulatory framework? What are the best ways to think about the future of digital competition?
Hi, Anupam. Hi, everyone. Thanks for inviting me out here. Let me start out by saying that I'm a person who has probably no legal connection whatsoever out here. I'm just a management professor and pretend to dabble in legal conferences every once in a while. Dr. Vijay, I do remember that conference very, very fondly. If you will, and the slides I made for that presentation, I still use in my class today. So therefore, the sunk cost that I incurred, and it's going to be a fulcrum of what I'm talking about today, is paying off dividends 12 years later. 2013, I believe, was the conference. So therefore, it's still paying off. And yes, there have been other visits to CCI on several occasions, on several other stuff. And many of the conversations I remember very, very, very fondly. So what I'll try and talk to you all about is, once again, I have been listening to Geeta. Geeta and I have been, I think she's a very dear friend, and I respect her a lot for, for a lot of things that she brings to the table. She's addressed my class also a few times. Good to see all of you and good to be a part of this conversation, long and short of it. So let me start out as to how I envisage digital markets in the Indian context. Recently, I published a report on Apple, which even got citation from, Tim Cook was the one who inaugurated it in every sense. We actually show that the ecosystem is able to propel a business worth around $6 billion in the Indian economy. That's the whole argument for a cell phone whose penetration is minor in the country as of now. right? So therefore, to me, I look at digital market a little differently as far as small and medium enterprises is concerned. Let me try to figure out how to articulate it best. When you think about a digital market, we typically think about reduction in transaction costs. So, for instance, I'm a seller in Kerala and you're a buyer in Arunachal Pradesh. We would never have met. So, therefore, the buyer in Arunachal Pradesh will have to make do with what is locally available. But with a digital market being present, the seller in Kerala and the buyer in Arunachal Pradesh are able to link with each other. So, therefore, in some sense, the competition is quote unquote moving towards perfectly competitive markets where large number of sellers and large number of buyers are present and everyone benefits from it. The holy grail of microeconomics, if you will. But now suddenly what happens, let's actually compare institutional voids that Ronald Coase talks about and a bunch of legal scholars have also talked about. Institutional voids in the sense that the buyer in Arunachal Pradesh requested a product from seller in Kerala and the transaction happened, but the payment didn't happen. Either the buyer did not pay the seller or the seller refused to ship the good despite receiving the payment. So therefore, in this particular case, a void is created where there's a lack of trust that develops in the economy. So when I talk about digital markets, when I talk about digital markets, I think the impact of digital markets is heavily moderated. The impact of digital markets is heavily moderated by the presence of institutional voids in a society. In a society where law is fast and quick and it is dispensed very, very, very efficiently, it's a reduction in transaction costs. In a society where the legal framework takes a while to react, it is not just reduction in transaction costs. That is, the buyer in Kerala, seller in Kerala is connecting with buyer in Arunachal Pradesh. It is also establishing a trust for the buyer in Arunachal Pradesh with the seller in Kerala. So therefore, when you look at the equilibrium in digital markets, see, I'm an economist, so therefore I love using the term equilibrium. I love misusing the term equilibrium a lot, so you have to be very careful about it. So to me, when I look at digital markets, when I look at even artificial intelligence, I'll come to that in a few seconds, I look at it from the point of view of trust management. Companies spend tons of money in building trust. For instance, if I were to stop teaching at IIM Ahmedabad and launch my own soap brand, I trust none of you would bother to even buy it. I don't know what all will come out along with the dirt on your skin if you were to use my soap. You won't trust me. But if a Hindustan Unilever were to launch a new soap tomorrow, every one of you would be interested in trying it because you trust them. So in order to establish that kind of a trust, I need to invest a lot of money. What digital market does for me is that it allows me to advertise to all of you at a much lower cost than a traditional market does. So therefore, that's why I said the sunk cost of entry into a typical market goes down significantly. Imagine pay-per-click. You can think of two advertisement models. One is carpet bombing in the middle of a brilliant TV show, hit and miss, probably a tiny fraction. Or you can think of a pay-per-click model of advertisement, which the digital markets typically specialize in. So what is happening is the sunk cost of investment comes down significantly. The variable cost starts picking up. Therefore, this is where the entry barriers go down. If you look at some of the most interesting competition cases that I happen to teach in the class, increasing the sunk cost of the rivals is a massive entry barrier. Now, here is where you're reducing the sunk cost of rivals. So therefore, my understanding is that digital markets provide the small guy, sorry for using the term small guy, but the small businesses, maybe SMEs, a chance to compete, in establishing certain market conditions that the big guy already has, but the small guy needs to create. To me, that's a context I put the digital market issues in. So therefore, when I'm looking at a report that IMA published recently, and even I had published a little bit with Danny Sokol and Nishant Chadda at ISB, we have very clearly articulated the fact that when a small firm uses digital markets, its ability to serve in multiple geographies increases significantly. This is something that I want everyone to kind of understand very carefully. The ability to find trust with the consumers increases by a manifold because you use digital markets. So to me, that's the first argument as to why an ecosystem like an Apple, an ecosystem like a Google, an ecosystem like Amazon is useful. Is it necessarily true that it is only used and there's no misuse of it? I'm the first one to say, yes, of course, there could be potential misuse. I'm not going to go into that particular direction. But the whole argument that I want to talk about is whenever any law, whenever any regulation is is being thought about on digital markets, I would like to believe that this is the balance. This is a fine equilibrium that we cannot ignore. What would happen to the small industry, small firms, if a particular regulation were to come through? So, for instance, and here too, again, let me again try and articulate a slightly different point, but very, very relevant to what I'm just talking about in this particular case. Imagine you see two stalls, that sell handicrafts in Gujarat, probably. Given that they sell the identical product, their prices tend to be at the bare minimum level in every sense of the word. They kill each other through ruinous competition. I think in some sense, what happens is in order to overcome this particular competition, firms innovate and come up with what we call as product differentiation. Maybe one firm sells handicrafts, which are Kutch region of Gujarat. Another firm sells handicraft, which is Saurashtra region of Gujarat. And a third handicraft store will probably say, I'll do a blend of Rajasthani and Gujarati handicrafts, and so on and so forth. I think platform competition also, trivializing it as I am, works in the same way. Platforms try to differentiate themselves. While some platforms offer ease of doing business, like Shopify comes up with this idea of no code, business dealing. Some other firm might actually say, yes, I want to do the business. I want to offer you security in every sense of the word. So therefore, these are the way I look at it is these are product differentiation strategies. Once you talk about product differentiation as a strategy, you need to figure out what are the things that an ecosystem needs to do in order to make sure that that product differentiation works out there, or that they're able to implement that product differentiation strategy. So therefore, an Android is very different from Apple, and an Apple is very different from other kinds of Samsung cell phone. Apple cell phone is very different from Samsung cell phone in every sense of the word. So the element of product differentiation and the element of reducing sunk costs for the small players are the two fulcrums around which the digital competition evolves. That's how I look at it. So therefore, now when I look at the regulation, etc., 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 I actually try to look at which of those equilibrium notions are damaged or perturbed, and how far would it take for the society to come back to this equilibrium should there be a change in the equilibrium because of a regulation. To me, that's the but-for world I'd like to create and evaluate any regulation against. So now let's come to artificial intelligence as well. The way I look at artificial intelligence too, and I'm sitting on the panels of quite a few startups that work with artificial intelligence, right from telling you which medicines are appropriate to you, to which food is probably right for you, to what kind of clothes, what color matches with you, or what decor is right for your home. Right from architecture to pharmacy to this to that to every service that you actually see, I'm actually seeing artificial intelligence penetrating and helping us. Now, is there a misuse there once again? Possibly. So therefore, my argument would be that many of these notions are perpetrated based on theoretical evidence. So for instance, along with microeconomics, I also specialize in a subject called behavioral economics. One of the big things, fundamental assumptions in behavioral economics is default bias exists. What is given to you as a default has strong gravity to what you do in life. In fact, actually, there's a very interesting anecdote I'll tell you, published, I read it in one of the books that I would do. People who use Google Chrome and Mozilla Firefox turned out to be far more productive than people who use Apple Safari and Internet Explorer. Let that sink in. Actually, this is a published study. The fundamental argument is that the people who use Google Chrome and Internet Explorer have overcome the default bias on their computers and are able to come out of Microsoft Edge and Apple Safari to install a new browser. So therefore, while the causation is not straightforward, the argument, there is a missing variable called a person who is more talented tends to use these two browsers because they are able to overcome default bias. So therefore, when I actually see many of these digital, regulations that are talking about, I again try to fit it in this world of default bias. Is it necessarily true that people would end up using what is given to them? Evidence from India, and I think I published a little bit in this side, evidence from India suggests that that may not necessarily be the case. So therefore, while I think it's theoretically very well established that default bias is a significant factor in human decision making, is it necessarily true when it comes to digital products in Indian context? I mean, Danny and I published this article very interestingly titled as "What Does India and Taiwan Have in Common?" Of course, I'm not going to give you any points for the obvious answer, but we're talking on Zoom, so one has to be careful in taking names, I'm sure. But nevertheless, the real answer here that I'm looking for is these two countries' citizens are voracious about regarding their appetite for consumption of new apps. So how much does a default bias work in the Indian context? That's a question that I actually have. So to me, as an academician, I look at the digital markets as a source of a fecund source of very rich questions as researchers. Does default bias apply in India? Now let's go back to the two fundamental ideas that I said: reduction in sunk cost and helping the small guy. How much of those assumptions are valid in the Indian context? How much is that equilibrium perturbed in the Indian context? Establishment of trust juxtaposed with reduction in transaction cost. I think these are some of the fundamental questions that I would like to leave you all with as we talk about. But the way I understand both artificial intelligence and digital markets in the Indian context is it is about the reduction of sunk cost. I'll leave it at that, Anupam, and maybe happy to come back in later if there were further rounds of discussion. Yeah, thank you.
Thanks so much. This gives us a lot of cues to research on default bias, on behavioral economics, which we lawyers are not actually, reading much about. So, from what I have read, it does have a lot of relevance to the market, and especially the digital market. Students, I think this is something that you really need to take a note of. And Professor, if you could also share a link of your Apple report, if that is open to all, that would be great. And I think we would like to take this great opportunity while Dr. Lalit Bhasin is with us, because he's the Bhishma Pitama of our legal world. The students have this great opportunity to, ask any question, interact with him for a few minutes because he has to leave soon. So it'll be nice for everyone to interact with him. And then, of course, we have some more time for Q&A with the other panelists.
So the report, I put it on chat, so you can popularize it the way you see fit.
Okay, thanks a lot for that. Dr. Bhasin, are you there?
Yes.
Okay.
I'm there. Yeah.
Okay. Asa, you may unmute some of the students. It's a great opportunity for them to interact with Dr. Bhasin.
If
Or on their behalf, if you can also ask something on their if they are shy.
if anybody wants to ask a question to sir, you may raise your hand. I'll give you access.
No question, but I would like to convey to our young students here, particularly what Mr. Sharad Sharma said, to be good human beings. Therefore, there is a big responsibility on the young law students and the young lawyers to give something back to society by way of professional social responsibility. That is very important. You will flourish as a lawyer, but then give a part of it, you see, to the society for professional social responsibility. Inculcate, you see, I request the law schools to inculcate these values and also to encourage the students to go beyond their law courses and to look into other areas, you see, to be successful lawyers.
Thank you. Thank you.
Thank you.
I have a question. Maybe it's not directly related to competition, but when we see artificial intelligence and we talk about having a legal framework for artificial intelligence in India, having an act for something what we have in EU, like AI EU Act, is it even possible to have one framework for AI, or should we go sector specific? Because AI, how it behaves in one sector or the repercussion it may have in one sector might not be the same in other sector. So, what is your opinion on that?
No, my view is that there has to be a combination of both. You see, there has to be a special approach towards a special legislation which covers, you see, like say competition law. It will not have the same inputs, you see, and same values so for other branches of law are concerned. Similarly, intellectual property rights, a separate approach is required for corporate laws, mergers and acquisitions. Therefore, it has to be a combination of the general law which governs all the activities, all sectors. So that is not sector specific. But in addition to that, there need to be rules and regulations, I think, which should govern the sectors also, because those will be very peculiar and special to those sectors.
Thank you so much, sir.
That was a good question, Professor Asta.
So, how would you guide the students not to just be Google lawyers or Chat GPT lawyers? How can they take from your experience, who had to actually go to the book, smell the book, read the book, and develop as a lawyer, and in the process also as a human being?
You see, a lawyer doesn't just have to look through the acts, you see. A lawyer's responsibility and the lawyer's knowledge has to be very broad based because we are living in an age of globalization. Therefore, what are the contemporaneous developments taking place? But more importantly, a lawyer should also know something about the history, culture, background, values, particularly in India, where you see our ancient philosophies like the Manu Smriti or Kautilya's Arthashastra, they still have so much of inputs to be given to our students. Therefore, those values have to be inculcated. When I said earlier in my remarks there are 6 crore cases pending, what is the answer? For answer, we have to go back to our ancient times when there was the consensual form of, you see, justice being delivered. Emphasis was not on law, emphasis was on justice, justice delivery. But now, unfortunately, due to the British intervention, there are many laws with hardly any relevance to justice being given. Although justice is there in the preamble of our constitution, justice, social, economic, political, but no one pays any attention and heed to it. Therefore, it is very important to go back to our panchayati system, consensual form, you see, to resolve our disputes, because foreign investment will come in only if they are sure that there would be immediate resolution of their disputes. But that can come only now in the form of not litigation, nor even arbitration, because arbitration has also failed to take off in India. It is through mediation, samjhauta, settlements. That has to be inculcated by the law schools among the students, you see, particularly the final year students. And that is my message to them, that try not to convert differences into disputes. Try to help to resolve those. Thank you.
Thank you so much, sir. We have three questions from our students. One for Dr. Vijay, the other for Dr. Geeta Gauri, and third for Professor Pingali. So I'll start with Gauri ma'am. So the student is asking, will crafting certain interim exemption policy help to balance the inequality raised by the discussion by your discussion, ma'am, Geeta Gauri ma'am? Can you please comment on this? Will crafting certain interim exemption policy help the balance the inequality? Do we have you with us, ma'am?
Yeah. The commission did come up with what they called as the 10 conduct rules of the digital area and the digital platform. And these 10 conductive rules are so general that they just can be used for the commission then to intervene. And they more or less borrowed from the European Commission. One is that you shouldn't have anti-steering prohibitions. There should be nothing that prevents something to be given only to one group and not to another. Then platforms, neutrality and self-preferencing. That becomes very important. Then there's a question of bundling and tying. Then there's a question of data usage. I had emphasized data usage because that was the most important thing in my mind. Mergers and acquisition, which means that really what is happening is, and Vijay brought it up, that mergers and acquisitions, which already was part of this entire ex-ante rules, has now got combined with the Competition Commission. Then deep discounting and dynamic pricing should not be allowed, and there should be no exclusive tie-ups and no search and ranking preferences. Now, these 10 conduct rules is fine, but I think the most important thing for the Competition Commission to understand is that as long as you regulate minimal, you just keep the regulation to the minimum and let competition come in. The small player and the large player will always compete with each other. And in this, I want to just state one more thing. The important thing to note for the Competition Commission is that there are no entry barriers. And the entry barriers are many. So they have to keep seeing which could be an entry barrier, which is preventing them from coming in. When we had this case where we had Flipkart and we also had Amazon coming into it, the idea was just to look at what would be the one which would act against them. These are big players, so they can always come into us. But the commission then decided, and I think it was my vote which was not accepted by the General Commission, it was a dissent vote, was it is best to let the markets function out what is preferable to them. I do not know if I've answered her question fully or just put my mind across to what I think is important to look at.
Thank you so much, ma'am. The second question we have for Dr. Vijay. The question is, moving forward, how to overcome the duplicity of law and enforcement structure in the present competition law scenario? How to distinguish the application on the small firm and big firm? What is the standard to be applied to address the misuse?
I think there cannot be a separate regulator for small firm and a separate regulator for a large firm. This is what exactly the Digital Market Bills tries to does that. Okay. And my suggestion was that you have a single regulator who takes care of the holistic situation. That is the idea. In fact, there is more amount of synergy required between regulators. This is a very much important area because one regulator cannot go in one direction, another regulator cannot go in another direction. And that is why, if you see Competition Act, there is provision of consultation between the different regulators, and that should more often happen. Because if you see Digital Markets Act, it will intersect with three different legislation. Probably Ministry of Telecommunication will come into picture, Information Technology Act will very much be there, Competition Act will be there from Corporate Affairs. And then there is, the data privacy will also come into picture. Now, if you involve trade, then commerce will also be into picture. So competition policy basically is a mix of all kinds of policy. And the question which Dr. Basin also answered was that you need to have these two regulators together, and there has to be a mix of it. So if you have a specific sectoral regulator, its objective is basically to look at technical regulations first, not competition as a generic thing. And if you look at competition regulator is a generic regulator which has an objective of correcting the market. So it may there may be a competition issue or a problem which intersects between two or three sectors, has to be dealt with by the Competition Commission if it has a competition angle. If it is a technical issue, and technical issue may also involve competition issue ancillarily, like for example, if we look at the telecommunication cases, or you can see the mobile cases of Intex, Micromax, that particular case, it has been very much brought forward there that the first technical issue should be solved. Justice A.K. Sikri's decision, if you recollect. So this is how the interface has to be drawn up. There is no straightforward or a straitjacket formula in regulation. So you have to have a mechanism by which all the regulators together sense the things and then move forward. This is what would be the approach which will be preferable. Otherwise, if you see for small players, there are already legislations like, for example, MSME startups. These are the firms which have been dealt with by separate legislation. They have got exemptions, and those exemptions are permitted under the legislation, and hence they are treated separately altogether. They are not subject to the normal competition regime because they are out of that. Similarly, they may not be subject to the normal taxation regime or normal regulatory regime. And I talked about sandboxes. So that is also a very important area where regulators provide sandboxes for smaller companies to work upon initially. And then when they graduate, then they are subject to the full-blown requirement. Yeah.
Thank you so much, sir. There's one question for Professor Pingali. The question is, do integrated digital platforms like WeChat, WhatsApp, Paytm, who deliver multiple services within a single app ecosystem, really create consumer welfare by offering convenience? Or do they risk harming competition by locking users into one ecosystem?
So I don't know if I have a direct answer for that. I think the answer is still yet to be found out. We are writing a paper right now, Hemant, at UC Davis, and I are writing a paper to exactly answer this particular question. But I'll give you an anecdote, if that serves. One of the things that I absolutely adore in life is coffee, and I have a very specialist who actually manufactures my coffee and ships it home. He sits in Bangalore, I sit in Ahmedabad. He happened to be my ex-student. One day he decided to use a service whose name I will not mention, and shipped it to me. The shipment arrived into Ahmedabad, waited for 3 days, and I begged them, please tell me the address, I'll go pick it up. You don't have to deliver at home. They didn't. And then the shipment went back to Bangalore because of lack of whatever facilities. And he got charged twice for shipping. This is then next time when it happened, he is a registered trader on Amazon. He shipped it to me. It arrived in 2 days. That's a standard shipping with Amazon Prime free for me. So therefore, this is the mechanism through which both these have happened. Now, therefore, tell me, if it were not my student, would I have ordered coffee from him again in the first case where the shipment has not come in time? The answer is no. So the advantage an integrated service will bring is that there is no apportioning of blame. It is a single party that can be blamed. I'm actually talking in a negative sense. That's okay, but there's no apportioning of blame to person A. I cannot say the truck driver screwed up, and the truck driver cannot say no, the shipper screwed up, and the shipper cannot say the payment gateway screwed up. There is a single entity. In a world of disaggregated entities, where is to be blamed goes away. I mean, the problem is it becomes disaggregated. Prisoner's dilemma comes into the picture. You can't make out how to make the system more robust. Now, to me, that's the fundamental idea. I go back, that's why I said, to me, digital markets, I understand from the point of view of default bias, trust, and sunk cost. These are the only three things that I use to evaluate a digital market. Trust is the fundamental aspect that gets broken in a disintegrated service. Trust gets established, in an integrated service. Is there a scope for misuse, therefore? Answer is possibly. Possibly. I'm not denying that at all. But I think the onus here should be on the victim to prove that there is a harm, irrevocable harm that cannot be done in any other way, than the other way around, right? I mean, so to me, that's the fundamental question. You want to gain trust, you got to give up something. There ain't no such thing as free lunch, as a great guy told us at one point in time. So therefore, if you want to build trust for small businesses, you really have to let go of some kind of an efficiency somewhere. That's how I would answer that question, Asta, at the stage. I hope I gave some answer to the question.
May I pass one comment from based on my understanding on that question from what I have read? Consumer behavior is not linear. So behavioral science tells us that when your behavior it may not be linear. You may behave in two different ways. You may choose one service and you may give your data, and you may trust one service and give your data, but you may not do that later on. So one is that the consumer needs to be a little more aware in today's day and age where
Just to extend your point, if I may take 1 minute. There is no other provision in digital markets that I see blood boil than this idea of surge pricing. Makes sense. It takes me, I mean, the reason why I use Uber Auto is because it takes me back to the nightmare of the times where I had to haggle for auto prices in Bangalore and Hyderabad streets, and it is terrible. And surge price reminds me of this. But we were just talking about it from a social angle in a class. One student raised his hand and pointed out something very interesting. What if Uber marketed it as driver making more money? You're getting a luxury. So there's a social angle to it where the driver's welfare is improved. The penny actually dropped. I mean, it's really not that bad. I can afford to pay that extra 50 rupees or whatever as surge price. And that might actually make a tangible difference in whoever is driving me out there. So therefore, next time when I'm thinking about it, I might actually have a very different view. I'm actually putting in a voluntary tip of 50 rupees more often than not only to get my taxi faster, but also I feel great looking at that guy. I feel less guilty looking at that guy as I sit in the back seat of the car. So therefore, this non-linear version of human behavior is a realistic thing indeed. And that non-linearity is the reason why trust building exercise has to be that much more robust. It is not an advertisement. It is an exercise that goes on for a while.
And when it comes to super apps or apps, anything integrated, any new business model, any innovation or any business solution for the consumer, if you have come up with a solution for the consumer that did not exist, I think it's creating a new market. I think it's giving the consumer a choice that they needed. So therefore, it's where is the question of harming the consumer? Now, abuse, like Professor Pingali said, can occur based on what they have done, based on their conduct, that can be examined as to how they are controlling the market and driving other people out, and therefore there is an abuse from any player, that is. But coming to these aspects, I also wonder, and I'd like to hear from Geeta ma'am as to why don't we have more empirical study of CCI cases so that regulation can be more suited to our jurisdiction.
That's a very good question, because they've gone and locked up all the cases.
Yeah.
And as a result, even me, when I wrote my book, I had to rely on my memory. And I don't think I have that good a memory, but it's a very important question why it is not allowed to be open and let people look at it. What does it matter? The case is over. But this was a request that was made even by those who put up the cases. They made the request that we don't want our data to be shared by others. And this data obsession becomes so important that it felt it's best to be put away, kept in a lockup, and not open, I think, for 15 or 14 years. I don't know how much time they've said they're going to keep it locked up. After which it'll be history. It's not very useful for competition law.
Okay. We can have one last question, Asta.
Shilpi ma'am, would you like to ask this question if you're here?
Thank you, Asta. No, so my question was just on the data-driven, the issue of trust that Dr. Pingali and Anupam was talking about, because that is such an important issue also from the other side, where we see that there is no information shared with respect to how data is being used by these companies. And we come to know later on, for instance, that data is being used to train AI models, and sort of a lot of people are their own data is taken to compete against them in these markets. So a lot of obfuscation happens. Shoshana Zuboff has in her book Surveillance Capitalism written about many instances where data-driven practices are not disclosed, and they are these large companies say they will correct them, but they don't correct them. And because we can't see it, and it's not very clear to us what is exactly happening, we don't know. And because we don't know, we can't take actions as consumers. So there's so much of information asymmetry in these markets, which in a classical economic sense is a situation that needs more regulation. So my question is, what about that aspect of digital markets?
Shilpi, can I make a comment here, which I found very useful for all of the others? Since the data is not available in the open, I found the best way to get into data is get into Google. And then they have all the cases. And they not only have all the cases, they also put up the cases in detail. So I don't know why the commission just doesn't allow it to take place. Have you tried it? You should try it out.
Yeah, thank
I don't know if Shilpi can hear me.
No, I can hear you, Dr. Gauri. My point was more on the market practices, Dr. Gauri. So we're talking about how these markets work so well, but I'm saying that there's the inherent information asymmetries in these markets cause failures, which are a quintessential situation where regulation is required.
Yeah, that's for the commission to take it up and look at it. But I brought this point up about the data availability because I find that many people keep saying we don't have data. How can we do the analysis? Perhaps it was what Anupam was stating. And I was thinking to myself, I've never been short of data. I've only been short of time to analyze and to get things together.
True. Professor Pingali, you'd like to take
Yeah, I just answer it one way. I think, without getting into the legalities, because again, as I said, I'm not a lawyer. My argument is it's a give and take here. It's a trade. Everything, whether it's public policy or a management decision, is a trade-off. So therefore, what are we trading off, and what is the decision for the country in terms of trade-off? The trade-off in Europe is different from the trade-off in India. Europe, the currency is transaction cost. In India, currency is trust. So therefore, do people even care? I'll give you one example. I was teaching a class with a lot of foreign students. It's an exchange term. So therefore, I had people from Europe and India. And the word privacy meant really different for two different people. When I go home to my parents and my good old aunt visits, she has no problem in asking me a question, beta kitna kamata hai? And if I say I don't want to tell you, my parents would probably be offended. Now, if at the same time, a European person asks his or her partner / spouse, that could be an intrusion of privacy in more than one sense of the word. So therefore, what is the right trade-off and which direction should the trade-off tip is a question at a national level. And that's where I hope CCI is looking at in terms of what our country's priorities are. At this juncture of development, I would tend to look at small businesses to be the key players. And when you do a survey of small businesses, what do they feel about the current laws. It's not as if the Europeans are thrilled with the GDPR guidelines and all that stuff. The paper that came out in Massachusetts, MIT Sloan Review of Management very clearly establishes that after the privacy laws were put in Europe, startup ecosystem has come to a standstill, more or less. Danny Sokol published it. I know the paper very well. So therefore, there are trade-offs. I don't know. You may have one view of the trade-off, and I would have a very different view of the trade-off. I loved the fact that when I searched on Google, vacation in Andaman, and opened my Instagram, I saw 4 advertisements for hotels on Andaman. I love that fact. Some of us may think it is freaky. So different ones of us have different views on which side the trade-off needs to go. And that's where I would assume that CCI and the other regulators in the country will need to take a view on in which direction it ought to be tipping based on the empirical evidence they see within the country. That's my take on the matter.
Getting back again to this question of privacy, which you have raised. Can you hear me?
Yeah.
The question of data markets. And that is where it comes up with this issue of privacy. That's why I kept saying it's not so much just platform markets, but the 2 smaller markets, data markets and markets for ideas. And here, does the FRAND help us? Or do we have to work out something very different just to make sure that privacy is maintained? And I agree with Vishwanath that the privacy of what your aunt thinks here and what your friend thinks abroad is different, but there's still a concept of privacy. And that Data Privacy Act has not yet come into full effect in India.
Thank you. This panel has been very, very enlightening. Thanks to all the esteemed dignitaries, starting with Dr. Lalit Bhasin, Dr. Vijay Singh, Geeta ma'am, Professor Pingali. We are really, really grateful that you joined this session for the students and for us to learn and to research further and be really there, running in the race and not falling behind because things are moving too fast.
Thank you, Anupam and Asta. Wonderful session.
You.
Very illuminating, educative, informative. Thank you very much.
Thank you, everybody. Appreciate
everyone.
inviting me.
Thank you so much, sir.
Thank you to all our distinguished panelists for your valuable contributions. We would now like to have a brief presentation by the MNLE Mumbai team.
Yash, are you there? Yash, can you hear me?
Yes, ma'am. I'm here.
You may start with your presentation. We can see you.
Am I audible, ma'am?
Yes.
Yes.
Just a moment, I'll present the slide. Yes, ma'am. Good morning, everyone. It's a pleasure to be here as a representative of the research team here at MNLU Mumbai. And through this presentation, we would like to impart to our esteemed dignitaries the basic idea behind what we are doing here and what we want the project to be and where we want it to go. So without any delay, I would like to start with the presentation. When we speak of competition in digital markets, we are no longer looking at traditional firms and gradual dominance. We are looking at ecosystems wherein scale, data, and network effects can make a player dominant almost overnight. On a global platform, the approaches have differed a lot. Uh, on one hand, with EU's Digital Markets Act being an upfront obligation, whereas the US continues with a traditional rule of reason approach and operates on a case-to-case basis. Our research takes this as a standing point and moves beyond law on paper towards a framework that is dynamic, evidence-based, and suited to India's realities. Uh, with regards to the standing committee report on the 25th report has highlighted both achievements and the challenges of the CCI, and it has highlighted that there is a growing pressure to shift from the ex post model which has been followed up until now to a ex ante approach, which with proactive obligations on larger platforms. The creation of the Digital Markets Bill in 2024 reflects this shift. Uh, similarly, the the committee has also pointed out certain gaps in the digital competition bill itself. For instance, the exclusion of virtual assistants and from the definition of core digital services and the absence of rebuttal mechanisms for the firms that are designated as systematically significant digital enterprises. The committee has also pointed out the risks to smaller businesses through killer acquisitions and predatory pricing by these dominant entities. These issues are especially relevant to India as MSMEs form the backbone of our economy. It has also flagged certain overlaps in the regulatory regime with respect to the Data Protection Act and the IT Act. Uh, it with regard even after flagging these such concerns, it has the writing on the wall with regards to the report is clear that although the urgency of a new regime has been noted, it cannot be brought on through strong rules, but also through strong institutions. Just through strong rules, but also through strong institutions. Our research has been significantly been influenced by the white paper titled Tech Regulation Gap Analysis, prepared by our very own Anupam ma'am and in association with the TechReg Forum. The white paper highlights that India's digital markets are evolving at lightning speed, but there exists a regulatory gap which risks fragmented oversight across different regulators and which can lead to discourage which can lead to which can discourage innovation if the rules are too rigid or too inconsistent. It draws comparison to regimes in the EU, wherein the Digital Market Act reflects a proactive stance, as we have established before, and relying on litigation as a precedent, wherein which leaves India in somewhere in the middle. Uh, we don't yet have a formal ex-ante regime, but our regulators and courts have shown willingness to push boundaries of the competition law, as seen in cases like Google Android and WhatsApp privacy policy. More importantly, the paper proposes a evidence-based modular regulation instead of a rigid approach, which can evolve with technology, and this forms a core part of our research. The message herein is that if India wants to avoid the risks of under-regulation and over-regulation, we need to focus on less rigid definitions and more principle based to adapt to faster moving markets. Uh, through these literatures and through our extensive research, we have arrived at a handful of key hypotheses which form the core of our research. Traditionally, competition law rests on a simple test, whether if there is a causal link between a firm's conduct and adverse effect on competition, uh, also known as the AEC standard. However, the BCB can be seen to slightly depart from this principle by imposing preemptive and per se prohibitions. This is a significant departure because it means conduct can be punished even without proof of harm. The legal risk here is, the most important risk here is fairness. A conduct-based regime risks being punitive against scale and efficiency, not just corrective of the abuse. This entails that success itself may start looking like a violation. And economically, the bill introduces a novel theory of harm, which prioritizes concepts like fairness and contestability over proven consumer welfare, which is, after all, the primary objective of the legislation itself. Uh, Fairness is important, but if we cannot define it objectively, we run the risk of type 1 errors, wherein the conducts are flagged as anti-competitive, even when they are anything but. The kind of overregulation that chills innovation. So our hypotheses herein deal with the bill's shift from effect-based analysis to preemptive prohibitions, which carries a serious risk of both legal uncertainty and economic inefficiency. Similarly, another key hypothesis which we have formulated is the targeting error of the bill, which can be seen through the issue with designation of systematically significant digital enterprises. A company may be designated based on the turnover or the user thresholds, but these metrics don't capture the true sources of market power, like control over data, AI ecosystems, or network effects. The risk is that the firms have simply won't merit get penalized. Furthermore, similarly, on a similar line, there exists an enforcement error. Uh, for example, if we were to take the anti-competitive practice of self-preferencing specifically, a blanket ban assumes that all self-preferencing is harmful. But in practice, it can also mean better product integration, improved user experience, and a higher consumer trust. If we regulate it per se, we risk outlawing the conduct that is actually pro-competitive, uh, and this is what we have termed as an enforcement error herein. Uh, and together, all of these flawed assumptions highlight a bigger danger. If the law is over-inclusive, it will create more false positives than genuine remedies. In short, we risk designating the wrong firms and banning the wrong practices. Through these key hypotheses, we have come across an inherent design gap analysis which exists within the institution and which can be put in these three issues. With regards to the approach of the regulator to the evidence which is available in the economic market, we suggest that instead of writing broad prohibitions, the law should be anchored in evidence about how markets are actually functioning, and that makes the rulebook precise, not presumptive. And with regards to testing how these regulations would work in the real life market, we suggest just like Dr. Vijay Singh sir mentioned, regulatory sandbox mechanism, which would allow policymakers to experiment to measure the real world effects of the rules and to avoid both false positives and false negatives. And finally, we also suggest a guiding principle when faced with a dilemma between innovation and regulation of anti-competitive practices. We suggest that the preference should be given to innovation over under over regulation, as the cost of stifling innovation just because just because it can be qualified as a disruptive technology uh, would would prove very harmful in the long run. So through this, we have arrived at the inference that India's problem is not just of drafting new rules, but of creating institutional capacity to apply them in a way that is adaptive, balanced, and forward-looking. And this brings us to the central premise of our research. Uh, Through our analysis of the competition bill, we have highlighted three key shifts which are required to take place. The first one being the shift from rigid rules to agile principles. Instead of punishing the companies just for being big, the focus should be on whether the conduct undermines fairness and contestability. And secondly, from assumption to evidence. As I mentioned before, as we have found before, the regulation should not rely on speculative fears, but on robust market practices uh, and studies that show actual harm, that ensure the rules are targeted and that they are credible. And thirdly, the reactive enforcement to collaborative governance, we need institutional tools like the regulatory sandboxes and a dedicated digital governance unit, which has also been touched upon by in the standing committee report, that make regulation an ongoing dialogue between regulators, the industry, and the consumers, and not just a top-to-down imposition. Uh, if we were to take these together, these shifts frame our central argument that India needs a regulatory philosophy that safeguards competition without strangling innovation. And the balance is key to future-proofing our digital economy. Uh, and in order to achieve all of this, we have put together a structured research plan, which will follow an impact-based comparative analysis of instances across jurisdictions, and that means that we didn't just look at the black letter laws in the EU and the US and India, but we have studied how these laws actually play out in practice, what market outcome they produce, and how regulators and courts reason through complex digital cases. Further on, we divide this research into two dimensions, the first one being legal and the second one being economic. With the legal dimension dealing with judicial reasoning and regulatory behavior across these jurisdictions, and the economic dimension, which is focused on mapping barriers to entry, foreclosure risks, and vertical integration into our own ecosystems. So the plan is proposed to be phased in three steps. First one being the legal diagnostic, which entails looking at global cases to identify gaps and understanding the policy rationale of the digital competition bill. The phase two will consist of market mapping, which will through which we will identify the dominant players in the existing market in that particular sector, and the entry barriers and the benchmark them against the global response. And finally, we will work towards building a hybrid model that is adaptive, modular concept for a hybrid model that is adaptive, modular, and tailored for India. Uh, through through framing of these phases and the model of research, we came across three pertinent questions, which were critical in guiding us through the research. First one being, how do we mitigate regulatory errors? Errors can be very costly, banning conduct that is actually pro-competitive or failing to stop practices that harm the markets. So we focus on developing legal economic tests that distinguish genuine abuse from legitimate product improvement. Uh, and the second question being, what evidence should define harm? As size alone cannot, as we have discussed before, size alone cannot be the basis. A firm may be large but still act pro-competitively. So we propose objective empirical metrics for consumers and market harm that move beyond the turnover or the user thresholds. And finally, uh, we ask whether if the regulatory focus should move beyond structural remedies towards interoperability and governance standards. Our research explores whether tools like data portability, open APIs, and techno-legal obligations can provide a more innovative, friendly path to contestability than simply breaking up firms or setting static thresholds. Each of these questions has forced us to look past labels and assumptions and towards a regulatory design uh, that uh, that we that is evidence driven and context specific and future ready. Uh, on the same line, through these questions, we would like to look at a few certain developments in our jurisdiction through these questions, so that we better understand what exactly what kind of questions we need to ask in order for us to come up with a concept for a model that is relevant to India for regulation of digital markets. With regards to the Google case, with regards to the WhatsApp case, uh, the wherein the policy, a privacy policy was introduced, uh, which came to the users with a take it or leave it approach, uh, as to sharing their data with not only WhatsApp but with its parent company Meta. Uh, So the CCI found this to be anti-competitive with regards to the privacy of the consumers being infringed and being harmed. However, the questions which we must ask, which we have framed through our analysis, are as follows. The first one being on a constructive dialogue: how should a government regulator work with a huge tech company like WhatsApp and Meta in this case to make new rules? If they order a company to share such information, uh, the government needs to make sure it is done in a way that doesn't make the app less secure or harder for the consumer to use. And the same is a very delicate balancing act, which we will have to explore. And moving on, should the evidentiary trigger for such a profound intervention, like in this case, uh, is it proven? Should it arise in case of proven consumer harm, or does market dominance alone warrant action? Warrant action as it did in this case. If we were to make such companies share everything through our statutes and regulations, does it remove the incentive for them, or does it influence them to build new and better things? Finally, uh, we asked the question whether making such companies who operate in the same market uh, opt for interoperability. However, well, it sounds like a great it sounds great for competition, but it's 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 complex. The biggest question here is, can we do this without breaking the things that make these apps work so well for the consumers who are currently using them, or we compromise that efficiency? If we were to compromise that efficiency, we might ultimately harm the very consumers we are trying to protect. This case doesn't offer easy answers. Instead, it provides a crucial platform to debate these principles. The path we choose will fundamentally shape India's digital economy, balancing uh, the need for market fairness with imperative for innovation. Similarly, in the case concerning matrimony and Google, wherein matrimony had alleged that Google was engaging in self-preferencing conduct by suggesting its own services over others, and promoting them as a search engine. The CCI, of course, found this to be imposed a significant penalty, and has directed Google to change how it displays its search results. However, in this context, in the context of our research and our presentation, what is relevant to us is the dissenting judgment, of dissenting opinion in this case, which tackles and defines anti-competitive practice as a whole. The core challenges it highlights are, of course, universal. The first one being, how do we distinguish between aggressive pro-competitive behavior that benefits users and genuinely anti-competitive conduct that forecloses markets? This this is a pertinent question which we seek to address and which we seek to uh, uh, bring to the notice of the dignitaries in order to facilitate dialogue. And the final question being, if the dissent warrants a per se trap, the risk that by creating blanket prohibitions, certain practices which might inadvertently punish the very integrated efficiencies, quality control, and innovation that the consumers value. The consequence of getting this balance wrong are significant. The consequences are whether we could either allow market destroying behavior to continue, or we could stifle the growth and investment that drive our digital economy. This, of course, isn't about a single company or a single case. It's about crafting a legal economic framework that is both robust and nuanced, and it fits the needs of the consumer uh, and of the market players in the Indian economy. So finally, the objective of our research, of course, is to frame a concept for an alternative framework for the future of digital regulation. We, of course, we have also proposed 4 key shifts, similarly to as we have discussed before, and the assumption to evidence with putting market study first, and rigid rules, and foregoing rigid rules to in favor of adaptive principles, and enforcement to co-creation. Together, these shifts form our alternative framework, one that avoids extremes of under-regulation and over-regulation. They form the gist of the alternative framework, and this is what we want. This is what we want the esteemed dignitaries here to comment upon and give us guidance that we will be needing. Thank you so much.
Rachna, are you there?
Yes, ma'am. Thank you so much for that presentation, Yash. We're going to be breaking for lunch now, but we're very pleased to announce that our guest of honor, Professor, one second. Am I audible?
Yes, you're audible. We are very happy that Professor Monty has joined already. So we post lunch will be continuing with his
Yes.
address, but right now we'll break for lunch and we reconvene at what time, Rachna?
Around 1:15, if I'm not wrong.
1:15, yes.
Yeah, and we'll pick up with Professor Monty's address. We're extremely happy to announce that the guest of honor has already joined the meeting, but he'll be addressing us post the lunch.
Thank you so much, everyone, once again, all the dignitaries and panelists who are going to join us post lunch also, and the ones who have already spoken. It's such an honor to be an audience to such a wonderful discussion. We reconvene at 1:15. So should we start, ma'am?
The panelists, next panel people are around.
Ma'am, I'll have to add Rachna as a panelist. Just a minute.
Yes, please.
Can we start now?
Just, I will let you know. Just give me 2 minutes. Ma'am, our next panel is also there. Professor Monty, are you there?
Yes, he's
Yes.
here.
Yeah.
Then you may start, Rachna. Rachna, can you hear me?
Yes, ma'am. Yes, ma'am. I'm starting. We are privileged to have Professor Giorgio Monti as our guest of honor, who's currently a professor of competition law at Tilburg Law School, Netherlands. Professor Monti started off his academic career in the UK before moving to Italy, where he led the law department at the European University Institute and helped in establishing the Florence Competition Program, which is a key initiative for research and training in competition law. He brings a very practical and economic perspective to competition law, which makes his insights especially valuable. It's truly a privilege to have our distinguished speakers from across the globe present in this event, whose diverse perspectives enrich our understanding and contribute immensely to the dialogue on India's digital competition framework. Professor Monti, if we could please have you address the audience.
Welcome, Professor. We are
Thank
so
you
glad
very
that
much.
you could join us. Thank you.
Thanks.
Look forward to
Thank
hearing.
you. Thank you for inviting me, and thanks in particular to Professor Asta and Anupam for having me here today. And I also would like to commend the students for their presentations earlier today, which was really fascinating and a very promising project. I put some comments in the chat for them. I hope they can receive them. I'm going to share my screen because I have a small slide deck to show you. I hope it's visible.
Yes, Professor, it is.
Okay, thank you. So the idea of the presentation today is to talk a little bit about what we can learn from the application of the DMA. In particular, I want to focus on two things, trade-offs. As a speaker said in the earlier panel, no regulation is perfect. Every regulation makes some choices, and these choices have advantages and disadvantages, and I think it's worth articulating. The second point is, as a comparative lawyer, we should not believe in transplants. So there's no point in transplanting wholesale the DMA into a country like India. As other speakers said before, there may be certain particularities about a particular market that require an adaptation of the law. So the point is not to suggest that DMA is an ideal solution, but it's a solution that has advantages, disadvantages, and the question is whether the same effects, same advantages, disadvantages play out in the Indian context. So my first slide is about asking why we have moved towards a sector-specific regulation. So the EU felt that applying standard competition law had a number of problems. It was very costly and very slow to implement the rules. A case like Google Shopping began in the early 2010s and concluded in 2017 just to get the Commission decision. And even today, we're still debating on remedies. Applying antitrust means the competition authority focuses on one specific form of conduct and not on the entirety of the behavior of the firm that it is considering, because you have to build a case by defining markets, establishing a theory of harm, and so some selection is made by the authority, and this tends to narrow the case. Also, each decision does not really become a precedent, because each decision is very much case-specific, so you cannot generalize from finding that Google self-preferences in search to generally prohibit self-preferencing and saying this is a general abuse that applies across the board. So in a way, tackling digital markets through ad hoc intervention here and there does not seem to really achieve the goal of creating competitive markets. Regulation has a better prospect because one can swiftly move to remedy. You can designate the firm with economic power and immediately require that they change their conduct. So rather than litigating market definition, is there an abuse, you immediately have a conversation about remedies. Regulation allows you to cover the entire range of conduct rather than just a single thing. And also a rules-based approach means the same rules applies to all gatekeepers. So all gatekeepers would have to comply with all the relevant regulations. And one added advantage to this is that the regulator can play off the performance of gatekeepers against each other. So if one gatekeeper complies in a particular way, that could be a precedent that you can say to the other gatekeeper, why aren't you also opening your market in the way your rivals are? So regulation shows some promise compared to competition law. Now, the first question to be asked is, who do we decide to regulate? And a lot of the discussion in the panel earlier on was this question of how do we decide who the targets of regulation are? Now, the DMA made a choice. It said, we're going to regulate gatekeepers of core platform services. So we're not regulating Google or Apple or Microsoft as an entity, but we're going to regulate certain services that those companies provide in the market where we find a bottleneck, where the service in question is a communication vessel between the business user and the end user, and Google or Apple or one of the other gatekeepers is using certain of its services to create advantages for itself. So the advantage of this approach is that you can identify a discrete service that you want to regulate within a multi-product firm. The disadvantage of this approach may be that different firms that are deemed gatekeepers have different business models. Amazon is a very different proposition from Microsoft. Apple is a very different proposition from Facebook, for example. And so whether lumping all these together in one regulatory system may be problematic. Now, some discussion was had, well, we should really regulate ecosystems. So Microsoft had its own ecosystem, and the regulated entity should be that. I think the disadvantage of doing this is that it's very difficult to then design ex-ante rules that apply very quickly. Of course, it's sensible to think about ecosystems. As I put on the slide, the platform business model is about extending or defending an ecosystem. So the concern we have with large players is that they start in one small market and they expand in other markets and they dominate the entirety of the services that the consumer wants. But it may be difficult to then design rules. So the trade-off is between rules that are easy to apply, which may be a little bit too strict, versus a more idealized system, which then becomes very difficult to apply in practice. Now, on why to regulate, I think this is well known, so I will not spend a lot of time defining yet again contestability and fairness. The point I wanted to make on this slide is more that while the DMA has very clear goals, it's not necessarily clear what the vision the DMA has for the future of digital markets. What is the idea about what digital markets should look like in the future? And how does one measure whether the DMA achieves these objectives? Do we measure them by asking, does the DMA facilitate the entry of new products, new entrants? Is it about changing the market shares of the incumbents in those markets? So I think some thought should be given when one has a regulation about, well, what do you want to achieve and what benchmarks are you going to use to decide whether what you're doing is going in the right direction? Now, as I said before, the choice has been to focus on some rules, not on standards, and not on bespoke regulation. So bespoke regulation here, I mean the UK approach, which says we'll target each individual firm and craft a set of rules that are applicable to that. The choice in the DMA was, rather than being very slow at deciding how to shape behavior, let's have some general rules that apply to all. I don't have the time to look at all of them. I just selected here some examples about rules in the DMA that are designed to open mobile ecosystems. And these rules apply to, for example, Apple, Alphabet, and Amazon. So these firms are required to remove default settings. These allows the end user to make better choices about what products to make. Concomitantly to introduce choice screens, which allows end users to switch, for example, browsers and search engines. The gatekeeper has to allow the user to choose what browser they want. This goes back to a point that has been made in the panel before about behavioral economics insights and about the power of defaults. And the DMA very much recognizes the power of defaults and tries to fight against it by facilitating consumer choice. This is not easy. Designing adequate choices for consumers is a tricky exercise, but the DMA goes in that direction. In terms of opening ecosystems, the third bullet point on this slide shows that app developers also are allowed to have better access to end users by, for example, being able to open alternative app stores to the one that Apple and Alphabet run, or allowing end users to sideload the apps rather than buying them through the shop. So indeed, while one make the claim that Apple and Alphabet's online platform and app stores are really beneficial for a number of users, it is also the case that Apple and Alphabet take a lot of the rents from business users and also foreclose market access to app developers who develop apps that are in competition with the ecosystem. And so the point of the DMA is to open the market for app developers. And finally, the ecosystem is also opened by facilitating interoperability with rival devices, something which is particularly applicable to Apple. So perhaps one point to take away from this is that while the DMA contains 18, 19 obligations that apply conceptually to all gatekeepers, it is important to bear in mind that some obligations are much more important for certain business models than for others. So we're speaking about opening mobile ecosystem, we're speaking about the firms listed on the slide. These similar obligations apply to a much lesser extent to firms like Booking or Amazon. I want to talk a little bit now about regulatory style. So with competition law, we have a regulatory style which is primarily based on deterrence achieved through high fines. In the DMA, we have a different style, which is, I call here a supervisory approach. And I think the most important articles in the DMA in this context, or in general, are Articles 8 and 11. These show that the gatekeeper has an obligation to demonstrate effective compliance. So the burden of proof is shifted. It's not for the competition authority to demonstrate anti-competitive harm, but for the gatekeeper to demonstrate that its conduct is effective in complying with the obligations in the DMA. This is advantageous because it allows the Commission to check compliance, and it has done so in a number of different ways. It has engaged in extensive regulatory dialogue with all the designated firms, and it also engaged with a number of would-be DMA beneficiaries, such as business users and consumers. So this allows the Commission to shape the conduct of the gatekeepers, not necessarily through enforcement, but through conversations. Of course, sometimes it has also used specification decisions when dialogue has failed. The outcome of this has been that we've seen what I've called on the slide incremental compliance. So hardly any gatekeeper complied fully on the day of compliance, which was 7 March 2024. But what we've seen is that the Commission nudges the gatekeeper towards improving its product offering towards compliance on a gradual basis. And gatekeepers appear to be responsive to this. Now, there are a couple of concerns with this approach. One is that the Commission appears to do little to guide the gatekeeper towards what is effective compliance. So it tells the gatekeeper what is not effective, but doesn't tell it what it is. The second concern may be that gatekeepers are using the Commission's relatively lenient conversational approach to game the system and stretching the dialogue period and therefore slowing down the implementation of obligations that should have been there. On the other hand, maybe this is as good as we can get. A point about institutional capacity, which was also mentioned by some of the speakers before. The Commission has been given more staff to help implement the DMA, but it's clear that the numbers remain below optimal. So I think whenever one decides on a new regulatory regime, one should ask, do we have the manpower to actually run the system? Nevertheless, the regulatory output of the Commission has been significant. We've had a lot of dialogue, a lot of non-compliance proceedings have begun, and 2 specification decisions. So in light of the small number of staff involved compared to the gatekeepers who can marshal a lot more people to defend themselves, I think the Commission has discharged its powers relatively well. One thing that came out on a study we carried out is the need for the Commission to improve its technical knowledge. So there's a huge informational asymmetry between the regulator and the regulated entity in terms of what the technology does and what is and is not possible. And the Commission has invested a lot in trying to build up its knowledge of the technology. And I think this is important for a regulator to be able to understand the business models that it is regulating and understand the technology and what it does. Another point that was mentioned earlier was the importance of whoever is doing the regulation of these tech platforms to connect with other regulators who are doing related work. And here the DMA has created a high-level group which allows for conversations between the Commission enforcing the DMA and other regulatory entities in related markets. Just in light of time, let me just get to my final slide, which provides a bit of a tentative assessment of what the DMA has done. I think there are a number of things that work fairly well. So by applying the DMA narrowly to certain core platform services, that allows for a quick identification of who should be targeted. Creating an obligation on gatekeepers to then demonstrate compliance makes enforcement easy. Of course, this is a trade-off. One could have had a model where we reflect more deeply about who has market power, should we show anti-competitive effects before we regulate. So the trade-off here has been in favor of quicker intervention in a selected set of markets. And I think the trade-off has led to certain advantages because we are actually now speaking about remedies in these markets. In my view, the regulatory dialogue the Commission has entered into has delivered changes towards improved compliance, not ideal compliance, but improved compliance. And maybe, as I said before, this could not be any better. And we've seen some new entry and some product improvements, particularly in markets like browsers, search engines, and app stores. And there are now alternative app stores available. So one owning an iPhone does not necessarily need to buy other apps via the App Store. Few points for improvement. It seems to me that gatekeepers do not engage sufficiently with beneficiaries. So the regulatory dialogue appears to be between gatekeepers, business users, and the Commission, but there should be more engagement between gatekeepers and end users and business users as to how their business model should be changed. The Commission could perhaps also signal its preferences to gatekeepers a bit more clearly, although this is tricky. I think the Commission doesn't want to be seen as over-regulating and wants to give the gatekeepers the opportunity to demonstrate compliance and to make the choices they want to make. And I think there is a challenge in terms of securing quicker compliance. We're now a year and a half into the DMA, and still we don't have perfect compliance. So I think there are some lessons to be learned in terms of speeding up enforcement. Thank you very much. I'm going to stop there. I'm happy to take questions.
Thank you so much, Professor Monty. It's a great snapshot on the DMA and what can be improved. Professor Monty is going to stay on for the discussion, so it'll be nice for us to ask him more questions as we interact later on. To set the tone of the next session, I'd like to make some opening remarks, like the competition law is enforced in more than 130 jurisdictions. Although most competition laws apply nationwide, many countries discuss and debate on the increasingly global impact. And EU has taken the lead by enacting DMA. Then we have several other digital competition regulations for so-called gatekeepers. Now, in these digitized markets, platform ecosystems are competing for the market. So there's competition for the market and competition in the market. That's how I look at it. So these platform ecosystems which are competing for the market, and there are millions of business users who are getting added on to the platform ecosystem every day. The Digital Competition Bill represents an intersection of technology, policy, and regulation. So in my white paper, which was briefly mentioned by the students in their presentation, we have attempted a comprehensive and holistic analysis of the implications of the Digital Competition Bill so as to find a balance on the critical role of regulatory bodies, policy initiatives by government, and reduction of consumer harm by the businesses. By analyzing the ex-ante framework and enforcement mechanisms, a techno-legal framework provides a holistic and collaborative approach to safeguard the interests of all stakeholders and regulate the digital platforms effectively. Now, what is missing is the statement of purpose for developing an Indian competition regime ex-ante. So what questions that remain unanswered in the report of the Committee of Digital Competition Law, according to me, are how do the rules incentivize competitive conduct along with innovation and compliance, especially by the entities impacted? Without a clear theory of harm, will the new rules accelerate enforcement? Can the recently amended Competition Act not serve the purpose? And will restrictive regulatory frameworks act as barriers that harm emerging competitive markets and disallow businesses to create value for consumers? So for India, more than what to regulate, we are still at the stage of why regulate, and do these rules rest on solid legal foundation? So let me start the discussion with this great cue from Professor Monty that we have now. May I invite Professor Shilpi Bhattacharya, to start off by giving her point of view based on any case that she would like to discuss from the Indian jurisprudence.
Thank you so much, Anupam. And it has been such a fascinating set of discussions from the morning, and also Professor Monty gives such a wonderful encapsulation of the DMA in such a brief time. I mean, that has to be like a record-breaking way of like summarizing everything so well. And thank you, Asa, also for having me. So, I was asked to speak about some Indian case, so I chose the WhatsApp case. The reason why I chose the WhatsApp case was because it is, I feel, a very, very critical area of digital markets. And I think this has been a very interesting order from the Competition Commission of India, because it's an area where we're looking at sort of data. And as everyone has said today, data is so fundamental. And the students made such a fantastic presentation as well, where they refer to the WhatsApp case. So I think we already know the background of this case. So this case concerns data sharing, aggregation, combination, which, as I said, is a key aspect of business models in digital markets. But it's not just about what this case addresses, but also sort of how do we remedy these issues. As Professor Monty says, we need to focus on remedies as well. And because we're still focusing so much of our discussion on whether there has been an abuse of dominance, we're not able to really discuss and look at how to remedy the abuse of dominance. So we see this also with the DMA's enforcement of Meta and the pay or consent model, that there are issues with how to remedy this. And the NCLAT, in its order on appeal from the WhatsApp case, has also raised the issue of remedy by sort of highlighting the concerns with respect to stopping the sharing of data between WhatsApp and Facebook. So the remedies in this case are going to be a challenge. But let's just first briefly talk about the case. So this case obviously is an abuse of dominance case where both exploitative abuse and exclusionary abuse has been identified. And the issue was with respect to updated terms of service that WhatsApp introduced, where WhatsApp said that either you consent to all of your data being shared with the Meta group of companies, or you stop using WhatsApp altogether. And that was primarily the issue. So the CCI has obviously, when we talk about the exploitative abuse of dominance, which is also interesting, I'm just going to highlight like what I find interesting in this order for ease of time. So the CCI emphasized that there are two principles here that are important. One is transparency and the other is choice. And these are essential to ensure fair competition in digital markets. So when we talk about transparency, the CCI's concern was that the terms of data collection were not clearly identified by WhatsApp. They were vague terms, they were broad, they were not easy for consumers to understand what kind of data was being collected. It was excessive data collection and not justified by the nature of services provided by WhatsApp. So the inherent opacity of these terms was considered to be unfair and preventing informed decision making in these markets. So the simple thing is, why can't WhatsApp clearly identify, okay, this is the data that we're collecting, and this is the reason why we're collecting it, which is what the CCI has said in its remedies that WhatsApp should do. But WhatsApp is collecting so much of data, and it wants to retain the right to collect so much of data, that it makes these terms inherently broad and excessive. And the CCI has identified that as problematic and an abuse of dominance in this case, which is very interesting to me. The next thing that they have identified that's interesting is the absence of choice. So not just how much data is being collected, but how is this data being collected? So you're collecting it in an inherently coercive manner through the take it or leave it provision, where because of the power of network effects, WhatsApp is so dominant that consumers do not have a choice with respect to whether they will use WhatsApp or not. So when the choice presented to them is share your data or don't use WhatsApp at all, that's not a choice that consumers have because of the degree of dominance. So therefore, that is inherently coercive and therefore an exploitative abuse of dominance. Again, an interesting point of view from the CCI. And this is also kind of linked to the European Court of Justice's Meta decision, where they said that dominance is relevant in determining whether consent to data processing is given freely. So we see sort of some similarity in jurisprudence evolving here. And then the other interesting thing, of course, that the CCI said, relying on European jurisprudence, was that privacy is a non-price parameter of competition. This is a big decision from the CCI because there has been a lot of discussion and debate on this issue, and the CCI, in exercising its jurisdiction in this case, has said that privacy law has a fundamentally different purpose from competition law. Privacy law occurs or is existing with respect to the rights of individuals. And the job of the CCI here is to enforce competition law, which is looking at how data is being used to exploit and extend power in markets, which obviously the privacy regulator is not going to do. So because data is such a central aspect of digital markets, the CCI has said here that they need to be vigilant about data collection and data usage practices so that data is used in a fair way and is not exploited to take unfair advantage and to create barriers to entry in markets. So this is a very important kind of a landmark decision from the CCI to exert jurisprudence in this matter. And I think this reasoning will apply even after the privacy law is fully enforced in India, in that the CCI can still exercise jurisdiction with respect to data-driven practices that create exclusionary abuses of dominance. I'm not so sure about the exploitative abuse of dominance, but I think on the exclusionary abuse of dominance, that should still apply. And also, when the CCI says that privacy is a non-price parameter of competition, it's inherently recognizing that that competition is happening on various parameters, and one of those parameters is privacy. And that's also an important point for the CCI to make. On the exclusionary abuse of dominance, I think what was interesting that the CCI said was with respect to the application of ecosystem-based theories of harm. Professor Monti referred to ecosystems as well. So the CCI says that data is a key to converting platforms into ecosystems. So when a platform collects data and then uses it or leverages across different markets, it can create an ecosystem that can lock consumers into that ecosystem. So it kind of uses this data aggregation concept to say that what we're looking at here is inherently an ecosystem, and that what WhatsApp can do by sharing this data is to advance its own ecosystem and to disadvantage rival platforms who may not have that ecosystem advantage. So, and essentially on the exploitative abuse of dominance, on the exclusionary abuse of dominance, the harm is not to competitors of WhatsApp. The harm that the CCI has identified is to the competitors providing online display advertising services. So the CCI is saying that competitors who are providing online display advertising services who do not have the advantage of this kind of data collection and aggregation to compete with Meta's display advertising, because Meta can much more precisely target digital advertising. They will be a much more attractive advertiser to advertise with compared to competitors of Meta. So the CCI is essentially saying that that competitors in the display advertising market are being harmed by this practice of data collection and sharing. which is, I think, also an interesting point for the CCI to make. And here the CCI also kind of does interview a number of these competitors and asks them how they will be impacted if Meta is able to increase its data collection practices. And then finally, I wanted to make the point about the pay or consent model. So, I mean, the issue here is how do we remedy this situation? And we see that because in the DMA as well, sort of now there's an acknowledgement that data collection, data aggregation, the use of data for advertising purposes can have harms and can be harmful. And so that's why it is also addressed in the DMA. But then the question becomes sort of how to design remedies for it. Meta sort of suggested this pay or consent model where they would offer an ad-free version of their product for a subscription amount of money. And the commission felt that this choice between an ad-free model and accepting personalized advertising violated the DMA because it did not provide a less personalized but equivalent alternative to the collection of data. So the question then becomes sort of what do we want, again, as Professor Monti said, like what do we want to achieve from our digital markets? And that needs to be identified very clearly, right? So what kind of digital markets do we want to see? And then we have to design remedies to address that. So I think the Meta case also raises this very critical question of remedies, like what kind of digital markets do we want to see? There are some very easy remedies like asking WhatsApp to identify very clearly what kind of data it is collecting and why it is collecting this data. And that will serve a certain purpose. And then sort of, if you want to have sort of push these big tech companies to really open up their business models, then you will do what the DMA is, what the European Commission is doing with respect to the DMA, and really push Meta to offer sort of a very different kind of service where sort of you don't have to pay, but you'll still get a less personalized version of the service. So that then becomes an interesting question. And thank you so much for this opportunity to present my views. I'm open. I would love to hear your thoughts on what I said. Thank you.
Great. Thank you. Thank you, Shilpi. Definitely, it brings up so many questions. So without any further ado, I'd like to invite Dr. Ambar Dhar. Do you think other jurisdictions, if you would compare it to India, have been able to come up with more parameters of abuse, or have they been able to define the digital market in such a way that abuse can be identified, harm can be identified? What are your views on if you compare jurisprudence in other jurisdictions that you have, because you've done a comparative analysis of more than one jurisdiction? So we'd love to hear from you.
Thank you very much, Anupam, for inviting me. It's a real pleasure to join you. I also want to apologize that I couldn't join earlier because I'm traveling and I only have intermittent access. So to pick up from what you've just suggested, I mean, my work has been on South Asian jurisdictions, and I think India, it's safe to say, is the first South Asian jurisdiction that actually considered, and in fact, amongst the forerunners in the world. So I think I have to zoom out a little bit from my work and look at the other Asian jurisdictions that have also experimented with, or at least tried to experiment with a digital regulation, a model. I also wanted to actually begin by talking a little bit about the report of the Standing Committee, because I found that very insightful. And I think that gives us a frame within which to look at the other jurisdictions to see how they're approaching some of the recommendations that the committee has made. I do want to say that on the whole, I think the committee's report is positive because it supports the ex-ante model of regulation. And I think that is very much the direction that a lot of other jurisdictions are also exploring. If I can just sort of aggregate or divide rather the observations of the committee into a procedural head and a substantive head, I was personally quite happy to see that some of the issues that we had highlighted in a co-authored article earlier this year, which was published in Pro Market, that if India is going to go ahead with the DCB, it should really think about CCI's capacity and ability to deliver on competition enforcement, and they've talked about that. They've talked about the digital markets department within the CCI, and I think they've also talked about what are the values that DCB is seeking to uphold, which is, I think, to Professor Monti's point, that we're looking at fairness and contestability rather than efficiency. So I think a little bit more capacity building on those issues. So they have definitely talked about it in the report. Some of the other things that they've raised I thought were quite interesting. They said India should be looking to develop a cross-sectoral framework, refine the DCB's thresholds so that they prevent the inadvertent capturing of fast-growing domestic firms. I'm reading from the report, so these are the words. They're also then, in a similar vein, they talk about protection of MSMEs from killer acquisitions. I think that's the same. They want the thresholds to be revised so that killer acquisitions are not, caught under it. They're talking about introduction of a rebuttal mechanism in exceptional cases for the designation process, which is, they want it to be similar to the EU's DMA, interregulatory harmony, cross-jurisdictional cooperation, and proactive market monitoring and consumer welfare. So these are some of the things that the report has highlighted for India, but I think that, in fact, India can even go further than this, because I think one of the things that the report doesn't quite capture is the enforcement mechanism for the DCB, and should it be as long-winded as what we have for the CCI? I mean, especially because we have the experience of the last 20 odd years, and the experience of not CCI taking a long having a long gestation period, and then a lot of cases getting stuck either in the appeal process, which is fair, but also through writ petitions. So do we want the same fate for the digital regulation? So with all of that background, I'm looking at the jurisdictions of Taiwan, Korea, and Japan. These are the 3 other Asian jurisdictions that experimented with some sort of ex-ante regulation in the digital space. So to begin quickly with Taiwan, in June 2022, the Taiwanese National Communications Commission released the Digital Intermediary Services Act. And this was largely modeled on the Digital Services Act. So although they were operating in the digital space, it was not the DMA they were focusing on. They were very much thinking about service providers in the communication and dissemination industry, intermediaries in that space. So I would have imagined that law would not have been as controversial as the DMA has proven to be, or the DCB, the kind of backlash it gets from business. Nevertheless, there was intense backlash for the DISA, and the idea was shelved before it could go much further. So even the draft, I think they said they would go back to the drawing board, but actually I have not been able to find out if there's been any progress on this beyond that 2022 draft. So I think for all intents and purposes, Vietnam has decided for now, much as it has endorsed the ex-ante model for the DISA, but it's actually not going forward with it. Korea is a really interesting space because they have actually tried various different options. For instance, they proposed in 2020, they've been trying, so last 5 years or more, they've been trying out different options. They proposed Fair Intermediation Transactions on Online Platform Act. It's a bit clunky, the name, but I think we can abbreviate it to FOPA. Which was primarily targeted unfair trades related to online transaction intermediation services. I think what I notice here is that the scope of the act is narrower than what India is proposing with the DCB. So India is a much, sort of all-encompassing scope, but that was not the KFTC's idea. Interestingly, they did also talk about the adoption of transaction value merger notification thresholds, and they wanted to also keep anti-competitive killer acquisitions under watch. So very much a concern that India has now, and it was also present in the Korean, the mind of the Korean FTC as well. And they were also reviewed their merger guidelines, and I want to tell you quickly about the other act. A more interesting act was the Platform Competition Promotion Act, the PCPA, and this is what would have been the would have called for the ex-ante designation of market dominant online platform operators or gatekeepers. So very much in the style of the DMA, this would have actually allowed the KFTC to designate certain platforms as gatekeepers, and then to also require them to abide by certain obligations, etc. And there were a lot of different obligations, including for abuse of dominance, some of the stuff that we've been talking about, self-preferencing, tying, a lot of these predatory pricing. These were the 2 or 3 main issues that they were trying to target as well in the abuse space, which was to your specific question. But interestingly, there's been a tremendous pushback from big business, and not just from big business. So I think now we're getting a little bit into the political economy space here. Also from the Trump administration. And they actually received a letter from the Trump administration in the course of the trade talks, which required them to rethink their law and required them to give a guarantee that the US platforms, US-based platforms will not be treated any differently from Korean, domestic Korean companies. And the Koreans have actually given that assurance. And I think this is as recent as August 2025. So I think just a couple of weeks ago. What we're now looking at, since September 2024, the KFTC has revealed a new strategy, and what they're trying to do is simply amend the Monopoly Regulation and Fair Trade Act. And there are lots of different amendments that they are proposing. They are adoption of separate. I'm just going to read out quickly the headlines because I'm conscious of time. They're talking about the adoption of separate thresholds for ex post presumption of online platform operators' market dominance. So we're now moving away from ex ante and getting into the ex post. The thresholds are actually quite sort of non-rebuttable. They're very much market share based. You can have different ways of determining the share of the market, but they don't. I don't seem to find any rebuttable option there. The practices they're looking at, as I mentioned, self-preferencing, tying, restriction of multi-homing, and demanding of most favored nation treatment. These would all be considered online abuses. They're also looking to increase, sorry, just lost my space here. They're also looking to increase the maximum administrative fine. So interestingly, much as India calls for a lowering of the fine, the guidelines here are actually trying to move from a 6% to an 8% relevant turnover fine. And they have specified online transaction intermediation platforms, online search engines, online video platforms, social network service platforms, operating systems, online ads as major sectors, and these will be primary targets of the regulation. So much wider in scope than some of the previous interventions. Interestingly, and perhaps unsurprisingly, there's been fierce resistance in the market, and it remains to be seen whether this would also see the light of day. As I mentioned, the ex ante has already been shot down, but the ex post is also receiving a lot of backlash. The third country that I quickly also want to mention, well, not very quickly, I think this is actually perhaps the most interesting country here. This is Japan. And Japan has introduced 2 acts which are aimed at improving transparency, fairness, and competition in the digital markets. And you can just see here from the words that this is very much in the same kind of focus on the market that the DMA proposes when they talk about fairness and transparency. I think that can be quite close to contestability, but I won't insist on it. I'll let people who know this better than me to comment on it. But the first act that we have here is the Act on Improving Transparency and Fairness of Digital Platforms, and this came into force in February 2021. What I found interesting here was the idea of co-regulation. And I found this interesting. I think in an interest, it is similar to what we have in the UK as well, in the DMCCA, where this is not this, you have high level sort of ideals for the digital market, and then the actual enforcement of those ideals is thrashed out with the with the operator itself rather than imposed from the top. I know that Professor Monti also mentioned that the DMA allows for these kind of negotiations, and indeed we've seen in the designation of the gatekeepers that these negotiations have taken place. But I think there is only this space of conversation in co-regulation rather than that being combined with the sort of more top-down designation model that we see in the DMA as well. So this is the TFDPA. This is the nice acronym, a bit clunky, but this is focused on online mall operators and app store operators. So what I found interesting about the Japanese Act initially, of course, was, and I think continues to be, that their scope has been quite limited. So the TFDPA has been limited in scope. And then the other act that I'll talk about in a minute, the Smartphone Act, is also limited in scope in terms of, what areas they'll be intervening in. The co-regulation model is actually quite interesting. It means that while the government sets out a general regulatory framework, it leaves the details around implementing the voluntary efforts to each operator. And the government then monitors, and this is again echoing the idea of supervision that Professor Monti talked about. And this is very much a supervisory role rather than an enforcer role. And we know in the DCB that the CCI was given an enforcement sort of very, court-driven litigation style intervention model, which I am not very convinced that would work. And I'm actually slightly disappointed that the Finance Committee, the Standing Committee on Finance, has actually endorse that rather than saying, look, this may not work, look at something else. But I think that this might be a good opportunity to look at other models and see how we can get away from court-enforced litigation, court-driven litigation model for enforcement. Here in Japan, the Ministry of Economy, Trade and Industry finds, if they find a potential violation of the Japanese Anti-Monopoly Act, then they can refer the matter to the JFTC, which is the Japanese Fair Trade Commission, rather than taking action itself. So what we're also seeing is that there's everything, both the actions are not combined in the same authority or in a, given to a department of an authority, but they're actually a separate and not entity, but one is looked after by the government and one is looked after by the entity. Again, they also provide thresholds for designation. I do not see this rebuttable option. Rebuttable takes us to, again, the DMA and litigation-driven approach, which, as you can see, I'm not convinced by. The other thing that they said, which I found very useful for this act, was that they are quite keen to combine an advocacy element as well. So to use the findings of this act to promote good practices to other people so that, the market can start sort of falling in line, as it were. And I think this is something, again, that the Standing Committee has also recommended, that the market studies are a way of also creating compliance and the culture of digital regulation rather than just relying on, hard regulation. The second act, which is intended to come into force on the 18th of December, I think the very well-known competition for specified smartphone software, and this is the Act on Promotion of Competition for Specified Smartphone Software, which is intended to come into force in December. And the JFTC is in ongoing dialogue, apparently, even till now with Apple and Google, while an expert panel has urged further digital regulation beyond the smartphone law. But at the moment, we don't even know whether the smartphone law will come into force and what shape it will take. The draft of the smartphone law suggests that it's very similar to the EU DMA, but it has some critical differences as well, which is, again, I think a space that India can really benefit from, investigating this more deeply, because I think some of these differences might be interesting for the Indian space. For instance, DMA has a direct downloading obligation, but the proposed act does not require designated operators to allow direct downloading. The DMA requires gatekeepers to allow developers using their app store to promote offers to end users free of charge. And the Japanese Act has no such requirement. You don't have, it's a negative obligation. You shouldn't prevent people from going to other app stores, but you don't have a positive obligation to provide them that information free of charge. And they also have a prohibition on self-preferencing, but here it's a rebuttable prohibition. So you can bring forward a justification to show why you were self-referencing. And in one way, the Act goes further. So while the DMA talks about gatekeepers to provide fair, reasonable, and non-discriminatory general conditions of access to their app, the Japanese Act goes further, and it prohibits unfair or discriminatory treatment of app developers regarding the use of mobile OS and app stores. I haven't been paying too much attention to time, so please tell me if I'm almost up, because then I can quickly wrap this up.
No, that's true. We need to now wrap up because we have 3 speakers, so we're running out.
I want to say the last sentence. I want to say that while all these things are very interesting, it's important to remember that the scope is very limited. So what Japan is trying to do in a more limited space, India is trying to do in a much broader space. So I think a lot of, this can be a space for interesting discussion, but I'll stop there. Thank you.
And then we'll get back to you with further engagement. So that gives us a good segue into market studies on intermediation. And we have Odi from South Africa who wanted to present, what South Africa has done in terms of, market studies and market inquiry, how we can, take some lessons from there. And Odi, again, if you could restrict, complete within 8 to 10 minutes, then we will have time for other speakers as well.
Thank you. Thanks very much, Anupam. Let me just quickly start my video. Right.
Yeah.
Oh, thank you for the wonderful morning. It's been a great pleasure to listen. I think this has been the best entertainment I had in months. I hope my personality is not showing. I'm quickly going to give a quick idea of what are the interests that we'd like to balance and where exactly does market inquiries fit in, because of the focus of the discussion today from my side. I'm going to look at the SA Online Intermediation Platform Market Inquiry and just a couple of words on the ECOWAS Digital Market Inquiry, and just returning to the balancing of interest to see are there potential solutions based on what we have seen elsewhere in Africa, also in relation to other areas. Just something interesting that I read in The Art of War: the wise win before they fight, while the ignorant fight to win. And isn't this so relevant today? The interest that we're going to try to balance as part of this whole process is, on the one hand, to have a strong and fast enforcement regime with as few externalities as possible. Also some kind of a broad regulatory reach, but then also critical is maximum innovation with low uncertainty for the market. And if we look at this type of a model, then market inquiries would probably fit in there. It's probably not limited to that area, but that is where I think it would mostly relate to. In relation to the SA Online Intermediation Platform Market Inquiry, they focused on a couple of areas which are not unfamiliar to India specifically. I'm quickly going to look at the findings and the recommendations of each of these, and just to keep in mind that in South Africa, this study was done from the point of view of small and medium enterprises. So some of the remedies that you will see will look somewhat on competition, because they try to make life easier for historically disadvantaged people. It's not typical competition remedies, so I'm not even going to spend much time on those. But if we start at the Google search, and India will be familiar with this, they basically found that Google self-preferences, its own shopping and travel results, and they asked for that to be seized. And they also said Google provides more prominence to its own results and also to paid results. And the remedies in that instance was for Google to introduce a SA-specific platform. With SA, I refer to South Africa, and to promote local platforms to augment content, reach organic results. And on paid results, Google has to provide a lot of money in advertising credits and training to South Africa, historically disadvantaged people and SMEs. Regarding online property online classifieds, this is quite an interesting area where private property was the main player in that market. Well, it's one of the dominant players. And what happened here, about 20 years ago, it was a platform for owners who did not want to pay agents' commission, so they sold their properties on this platform. Later on, private property decided they are going to get agents to also list their property on their platform. And later on, they decided, let's incentivize even more agents to make use of the platform by creating an estate agency property portal company. And the same agents that are basically our customers will now be our shareholders. And those agents had a seat on the board of private property. They held a 12% share. They got dividends in the company, and they also got very good rates, preferential rates for listing their properties here. The same agents there were also part of the Real Estate Association, and private property also entered into an agreement with the Real Estate Association that the association must publish they must promote private property as a platform. And that resulted in other platforms being disadvantaged in the process or being excluded. There was also issues regarding the embedding of agents onto this platform because there were multi-year agreements and also significant price discrimination. And that was an issue in relation to small and medium enterprises. Right, so what did the Commission say? The Commission said that this whole structure must fall away. This agreement between the Real Estate Association and private property must be diminished. No more multi-year agreements and no more price discrimination. There was also another area, which is syndication software, where private property was involved. And what this software basically does is it pulls information from the agent's website onto private property's own website. And then private property would then push it onto classifieds sites, but only a very limited number. And one can understand that because private property is actually active in that market as well. But that differed from other syndication software providers because they would not only pull information onto their own sites, but distribute it to so many other classified sites. And private property said that we are happy to pull in your sites, but we will charge an amount for that. And the Commission said as part of the findings or the recommendations, you don't charge for that, and you will make sure that there is complete interoperability between all of the syndication software. Right, in relation to the auto online classifieds, the main issue there was basically extensive price discrimination because the pricing was based on volume and not cost, and the remedy was for platforms to substantially reduce prices to SMEs. Regarding app stores, and you would be familiar with this, the findings were unconstrained commission fees, anti-steering rules. There were no payment options that existed, and there was also no SA curation of apps. And the remedies were to allow for the steering to the own websites of the app developers, as well as the use of own payment options, the allowing of continued free use of the website content, compliance with the European imposed measures regarding apps, also in relation to fair and reasonable pricing. In relation to food delivery, this was also quite interesting. Here we would basically have Mr. Delivery or Mr. D Food, and here we have Uber Eats, large restaurant groups and independents. And what the Commission found was the major food delivery platforms charged below cost for the large restaurant groups, but they actually charged 2 times higher commission to the independents. And Mr. Delivery Food also charged, they incorporated a high surcharge to customers, but customers didn't know that. So customers also didn't know that the independents were basically cheaper. And the reason why the customers didn't know that was because of this wide parity clauses that were a part of the agreement between Mr. DF and the last restaurant groups. So what were the remedies? It was basically for the Commission to monitor the whole issue of below cost pricing, They told Mr. Delivery and the others to notify customers of surcharges that are being paid, to do away with wide parity clauses, to allow local franchises to accept local delivery new entrants within particular guidance or guidelines, and to provide independence with a tiered commission structure and a rebate structure. Right, regarding online travel agencies, they basically also established that Booking.com enforced wide and narrow parity clauses, and both of them had to be removed. Regarding e-commerce, this was also an interesting case where Takealot operated. Takealot was vertically integrated. So Takealot operated its own retail department, but it also sold that through Takealot Marketplace. And third-party sellers also sold through Takealot Marketplace. And one can immediately see the conflict here. So what did Takealot do? It also imposed parity clauses on third-party sellers. So that meant that parity basically means that your third-party seller is not allowed to advertise anything that's advertised on Marketplace at a lower price on any other site. Also, very interesting, Takealot, the moment that he discovered that it's being competed away by third-party sellers, it forced these sellers to increase their prices so that it can do better. There was a slow dispute resolution process. There were also difficulty for new players to be onboarded. Takealot used all of these third-party data to develop its own products without having to incur the cost of product development. And it promoted a kind of a buy box on the basis that products were available. So it wasn't a buy box based on cheapness, but on availability. And because it had all its products in store, everybody would buy its own products. So what were the remedies? There must be a complete separation between retail and marketplace. No use and no access to third-party data. So this problem got solved and that problem got solved. The buy box had to be based on not only the fastest delivery, but the cheapest delivery. 60-day dispute resolution deadline was put in place. And there were some remedies in relation to the onboarding of new players. Right. Also, customer relationships had to be improved. In other words, if there were issues regarding mistreatment of third-party sellers, then there would be a disciplinary hearing. So that's basically what the SA Market Inquiry found. Regarding ECOWAS, now ECOWAS is a large economic community in West Africa. It consists of 12 member states. ECOWAS did a market study and they focused on e-commerce and online financial platforms, informal and the informal sectors. They focused on online advertising, marketing and search engines. The member states compiled their own individual research reports, but many of them are still in the process of validating. But I think that is something to watch out for. That I think there will be some interesting insights from 12 different member states. Right, so this is basically in relation to market inquiries. Now, why is this a good tool? I think first, it captures restraints impacting competition at scale. So to the extent that one would find interesting cans of worms, like in the case of private property or the case of the estate agents, that would help one to make sure that those types of restraints do not exist in an economy. Certain structural restraints are difficult to detect for consumers, and this is why it may be useful for authority to do that. And complaints may be less forthcoming from the market. It is a very expensive thing to do, but I think the CCI has already invested and investigated in various digital markets. So I think there's already a lot of intelligence in that regard. I think, and that's just a personal perspective, is that if one would incur the cost and go into the whole process of a 1 or 2 year market study, make sure that whenever you come up with remedies, that they really move the needle, that it's not just flimsy. Right, the second important issue pertains to strong, fast enforcement with few externalities. And there I think there's a lot to learn from governance innovation, and I'm just going to provide some quick examples and suggestions. And the one pertains to the creation of a rapid response unit. If one can implement rapid timelines, not only at the CCI and for purposes of the judicial review process, that could help a lot. And if there is something to legislate, maybe this is something that one can legislate based on the great benefit to the public interest. Precedent that we have in this regard is the Namibia Competition Commission. About 5 or 4 years ago, they decided to implement such a system to protect SMEs from exiting even before a complaint has been investigated. And also in South Africa, there was a directive issued during COVID, and that basically provided for very, very close timelines, as you can see, within which decisions must be made and reasons must be issued. And this can be done. It showed this can be done. So this is perhaps something that can be considered in relation to very specific complaints that are filed, that is not overly broad and that will not result in a lot of externalities. If we look at the issue of maximum innovation and low uncertainty, here again one can look at precedent on light provisions and also governance innovation. And here we see the Kenya Competition Bill. Kenya is one of Africa's most tech-savvy countries. They have a competition bill that's currently in the process. We actually thought it should be approved by now. But yes, they also refer to the different categories that is present in the digital competition bill, but there's no designation, there's no criteria for that, there's no obligations, no conduct provisions. And that's not necessarily a bad thing, because certain conduct may be necessary for purposes of successful entry and the creation of an initial ecosystem for innovation. And let's just quickly have a look at competition regulatory innovation. Anupam, as you mentioned in the beginning, there are gaps between the law and the real life. I couldn't confirm it better. I've been in the competition economics and law and policy space for 15 years before I started Betweenity, and it was like day and night. The law is much more anemic, it is much more mechanistic, and if I can provide a word of advice to the students on this call, is start a side hustle, hassle, that's a Freudian slip. Start a side hustle so that you can understand what is the difference between competition in real life and competition on the books, because it differs to a significant extent. While microeconomics is good at describing market structures, it's not suitable for interfering. You need much more insight into markets to interfere. Also appreciate the benefit of size and monopoly. And it's fascinating to see in Africa there's some kind of a resistance to its monopoly. In fact, last week we had some change on that topic. We had a webinar with the East African community. They will now start implementing a merger regime. And I specifically asked them, what is your view on monopolies? And they had this refreshing answer of, we want our firms to be dominant. And I think that is something that one should embrace, because how else will you appreciate monopolistic competition that Prof. Pingali referred to? It's also important to appreciate and develop a much more fluid concept of competition. We are taught, especially at competition authorities, to think in terms of a lessening of competition on the one hand and competition on the other hand. But it is a much more fluid concept that spans a spectrum. And in South Africa, the Competition Tribunal had its hands full with the Commission, because everything is considered to be anti-competitive, regardless of where on the spectrum it is. It is so indoctrinated to punishing anti-competitive conduct that there's no appreciation there. And I think that is critical to develop this expertise from a regulatory and governance innovation perspective. The nice thing about perhaps this model is that it is completely reversible without any significant bad permanent damage to a market. So that's been my contribution. I'm very happy to take questions a little bit later. Thank you for your time and for the opportunity.
Thank you. Thank you so much, Odi. This was indeed a brilliant presentation and very, very different perspectives, especially on the flexible governance model, which is reversible. May I now call upon Thomas Hopner, you're leading in the space of ex-ante regulations, and there are so many lessons from the rest of the world, different continents. It'd be nice for us to hear your insights and lessons that we can learn.
Yeah, thank you for the invitation to share some insights from Europe. I think I have 10 minutes, so I will try to keep it short and to the point in the interest of transparency. As you indicated, I'm advising several companies and associations in relation to designated gatekeepers, not for any of those, always against them, but I'm also advising platforms that have a dominant position on national markets. I've been doing this since 2009 now with various complaints. The first really all based on general competition law, Google Shopping, Google Android, Amazon Buy Box, Apple ATT, Teams. So I was involved in very many, I would say, investigations that tried to solve these issues with general competition law. So I could see firsthand what works and what does not. And because of these shortcomings that I witnessed, I was a strong advocate of the Digital Markets Act. And by now, I can see that it delivers. In Europe, we've seen now that the designated gatekeepers do not roll out certain features that are criticized in many other countries and will lead to competition investigations there, I'm pretty sure of. We've seen more transparency, we have seen more market entry, and this is the direct result of the Digital Markets Act. So I also followed the development in India with great interest. I liked some of the anti-Google cases, some followed European examples, and it was also interesting to see how you equally struggle sometimes to identify the harm and to get all the empirical data together to make your case. So I also like the idea of a digital competition bill, and earlier today, but also in the latest report, I learned about some general kind of resistance or arguments against it. And I would like to use my remaining minutes to maybe address some of those arguments, or some could say myths. Let's start with some more general ones, and then I become a bit more specific. So there's this general idea that if you regulate, somehow this kills innovation, and some even suggest, any kind of regulation is per se anti-innovative. I would say the opposite is correct at the moment, where you have full control of ecosystems by certain companies. They can suppress and do suppress any competition and any innovation that comes out within this ecosystem that could threaten their core business models or any new endeavors they may have in mind. And as long as they can control that and suppress innovation, we will not see it. So one of the objectives of the Digital Markets Act, and Professor Monti's brilliant presentation also touched on that, is of course to open up markets and to give market access to those innovative, primarily small companies that really still think about how to make products better. Then there is the second criticism, that somehow regulation reduces the incentives to invest, in particular in India, and in particular of large international firms that would be addressees of these obligations. Now, I think this is quite naive to assume. India is a huge market. It is very attractive to any investor, any company. You can't do business on a global scale without being in India. Secondly, you should be worried about incentives to invest by your national local companies. And as far as this saying and this test by investors, what if Google does it, still holds true, you have a problem. And I can see this with the companies I advise every day. If they want to bring up a new product and they look for investors, the first they ask is, what if Google does it tomorrow? Can they kill you and adopt your product and just roll it out themselves? If the answer is yes, or possibly, because there is nothing to stop them, they will not invest in your national services. So if you think about investments, you also have to look at the investments at this level. Third point, and that was raised early on by Professor Pingali. There is this presumption that he issued that somehow regulation, contestability, and fairness reduces the overall advantages of effective digital ecosystems. Now, no one, and if you read the Digital Markets Act, nothing there suggests that there is any criticism about digital ecosystems. These are ecosystems because they can work very well. However, it is not true to suggest that only ecosystems with anti-competitive conduct in it are effective. In fact, I would say the very opposite. Digital ecosystems will work much more efficiently for everyone if we have no anti-competitive conduct within it. Because what we see at the moment, all those efficiency gains that Professor Bengali suggested are not currently passed on to businesses or to consumers. They are fully transferred to the shareholders of those in control of the ecosystem. So you have no economic advantage of these efficiencies because they don't land where they should land. They land in the pockets of those in control. The next criticism then is, and I read that in the latest report, there is some fear that India may not be capable of dealing with ex-ante obligations because it puts too much of a constraint on the authority in terms of capacity, that you don't have the capacity to do so. I think this is not correct, because you have to deal with the anti-competitive conduct if you want to or not. If you don't have ex-ante regulation, it falls back to general competition law. So meaning a case-by-case analysis. Let's just take the current 10 obligations under the current proposal. 10 obligations for, let's say, 5 gatekeepers means 50 cases. So under general competition law, you would have to bring 50 cases, 50 individual analysis, dominance, harm, theory of harm, effects, objective justification, 50 investigations. And if you look at how long they take, how much resources they take up, it's naive to assume for a second that ex-ante regulation could lead to more capacity constraints. The reality, it is leading to less, because the more precise your obligations are, the more legal clarity there is, the less cases you have to bring. So I think that is pretty clear. Also, the idea that you now need more specialists in the authority, well, you need them anyway. If you want to bring serious cases in this realm, either under general competition law or a specific regulation, you need those experts. And just because you don't have an ex-ante regime doesn't mean you can live without them. So I think this is really a false premise. Now let's turn to the question, could we not solve this under general competition law? And I think this is a more tricky one. I refer to the German example, and that hasn't been mentioned yet, and I don't think even in the report. Germany obviously tried to solve it under the aim of general competition law. And I would say it's more about what you want to achieve. I think the core outcome needs to be that you require additional obligations for those digital platforms that have particular power across markets. And these additional obligations need to be so crystal clear and reduce the need of a case-by-case analysis with showing any anti-competitive effects and analyzing tons of data that it slows down the case and then it's dead. So you need additional obligations that are fine-tuned to digital markets. Where you embed them, whether in a general competition act or whether in a distinct act, I think this is a matter of taste. But the outcome must be kept in mind. But I can see a very well working general competition regime that has, in addition to the general rules on abuse of dominance, more specific obligations for specifically designated and defined large companies with digital market power. So I don't think there is a contradiction as such. It's more about finding the right criteria for identifying the right companies and obviously then for also imposing the right obligations that are suitable. this leads me to the overall question, well, why do we need this? Well, I already touched upon it. The main issue is speed. These are dynamic markets. If you wait until some harm has materialized, and then you bring a case that takes years, you may as well leave it. I'm probably one of those that is the main victim of that, because I've won several cases, but the clients are like, well, nothing has changed, or we are kind of insolvent by now already, and now it's all about damages. But damages is the second best solution. You want the market to be corrected before it's too late. And this is really at the core of the debate, and it should be. These platforms are following the pragmatism of move fast and break things. And if something goes wrong later on, ask for an apology, but never ask for permission. And with this mindset, let's just do it. And if it's wrong and illegal and anti-competitive, later on they will tell us, and then we will just accept it and pay a bit of a fine. With that, you are creating incentives to anti-competitive conduct. And that is the current state of situation. And you need to counter that by being very precise in advance. This is not acceptable here, because we know from empirical evidence, from the cases we've brought, from everything we've learned about economics in these markets, this will lead to anti-competitive outcomes. So this then leads to the next criticism that we've heard earlier on. It's about the risk of type 1 errors, over-regulation. I would say that the starting point should be the opposite. At the moment, we see the materialization of type 2 errors of under-enforcement. Under-enforcement has led to a situation where many, many companies are totally dependent, and this dependence is not serving any economy. And we need to turn this around. So the crucial question is, how do we reduce the risk of over-regulation? And there, I think the key aspect is the designation process, so that you only impose those obligations on the right for platforms where they are suitable, and don't impose them on any platforms that don't pose a serious threat to your economy, where you could really talk about over-regulation. So including aspects such as discretion, when to designate, presumptions and rebuttals is the right way forward. Last point, and then I'm through. There was this idea mentioned earlier on, well, why do we need specific regulation? Why don't we enter into a regulatory dialogue? Let's just have a sandbox and then go through the process together. The problem is the threshold between a regulatory dialogue and regulatory capture is very small. And the more involved an authority gets and becomes into the rollout of a new product, a new feature, the more it will see that it suffers a total information asymmetry, and it becomes kind of a companion or a supporter of what the digital company is doing. And the more involved it gets, the more difficult it will be to say later on, well, actually, I've made a mistake. I didn't realize that the actual impact of what you are suggesting is this, because you never shared this information with me. And we've witnessed this in the UK case of the Google Privacy Sandbox, which sounded good. Let's go through this process together. But at some point, they realized, well, we didn't have the full picture in the beginning. If we had, we would have been much stricter, and we may have said, no, there's no way you can do this. So it was a long learning curve that didn't lead to the envisaged positive outcome. What is the conclusion from all this? I think in reality, if we've seen what happened in ex post enforcement and how ineffective it was, and we're not even talking about remedy and non-compliance, there is no way past ex ante specific regulations so that there is more legal certainty and the companies knows what they can do, what they cannot do. What you should really focus upon, and I think this is the way it is going, is to fine-tune the designation. And we probably need to move away from the idea of a revenue or turnover-based designation, because there are small firms that can be very profitable, but they don't pose any systematic risk. And then, of course, we need to address the shortcomings we've already seen in the Digital Markets Act, including the aspect of incremental compliance that Professor Monti mentioned earlier on. But overall, you have to keep in mind, even though you are kind of still technologically kind of developing country where still a lot of things are happening and more people want to use the internet to start off with, you have to prevent from the very start that your economy turns into what some have called a colony that is so technically dependent on players that don't operate in your territory, that whatever they do nationally, they will have to effectively pay a rent or transfer their margin to foreign companies. And then, okay, it's working, it's doing well, but none of your businesses can really grow and scale up globally because there's a natural shield. And what has been mentioned earlier on, if then the Trump administration is having an issue with that, isn't that telling you something that there's actually probably more at stake here than just some business development? We are talking about national independence, because the more powerful foreign platforms are, the more control they have about every element of an economy, including media plurality, elections, and everything that comes along with this. So this is a much more fundamental issue. And the idea that just because some foreign governments have an issue with you regulating should probably not be the main thought in your head, because it may only confirm that you need to secure your national independence. Thank you for your attention.
Thank you so much, Thomas. I think for the first time I heard so many more reasons in favor of ex-ante regulations, more than just that, we just could not catch the abuse in good time, and we exposed has been, has not given us the kind of remedy that was required for these platforms. So I think with this picture now, we would like to invite Amrita Chaudhary, who leads a big think tank and regularly interacts with a lot of stakeholders relating to the technology platform. And Amrita, what do you have to say now? We have so many benefits for ex-ante regulations. So how do we create a balance, and what would your stakeholders think in this market?
Thank you, Anupam, for having me here, and MNLU for having me. While there were other points you wanted me to touch upon, and that is what I was thinking of speaking.
No, please go ahead with your points.
Yeah, but I think I'll go to some of these points and I'll link it back to it. And just for everyone's clarity, I'm not a lawyer. I'm not a competition specialist. I work on tech digital policies, and I look at it on how it impacts internet users, non-users, as well as small businesses, etc., from the Indian perspective. So my responses may not be very legal or competition accurate, but that's how we look at entire things, including how the geopolitics currently is playing. So, and I have been listening to what all the speakers has been saying today, and I resonate with quite a few of them, and obviously in some I do differ also. But I think one thing we all agree is the digital markets are very complex. How things manifest is not a 0-1 game. There is a lot of gray. So it's not, this leads to that. There is a lot of intermingling of things. Like, for example, if we are saying yes, and we do understand the power of big tech is huge, their impact is huge. We also need to see in a good way, they have also helped a lot of small businesses come up, like what Professor Vishwanath Pingali was speaking about, as in many of the small businesses are dependent. Perhaps they may not have been able to get the scale without the big tech. We like it, we hate it, but that's also a fact. The other thing which I would bring in to the table is, and which even Vikas Singh had mentioned, is that the Indian markets, and even Sharad was mentioning, is the Indian markets are different. It's more complex. The Indian government's aspirations are also different. On one hand, we want the digital economy to thrive. On the other hand, we want to protect our markets, as well as not allow, companies to misuse, or become too much dominant on certain things. We want people to have jobs. So there are a lot of interests which India wants to balance. So I think what the government or what India wants to actually achieve is very important when we frame everything. The third thing is the competition rule which came in was amended in 2023. When in 2024, the DCB, the Digital Competition Bill, started to be discussing. So we didn't even try using the Digital Competition Bill amended before we jumped into it. Yes, it is important to discuss it. But I think what Vikas was also saying is that could that be amended a bit to kind of achieve what we want to do and simultaneously look at this market? Because I'm sure many of you also agree that some of the definitions, etc., which were looked at by, when the draft came in, were a bit problematic, as in there was a lot of generalization of how the digital markets work. Similarly, there was not much differences made between how, say, for example, a search works, or even, the other core businesses work. Also, while we understand that tying and bundling may be problematic, but not all kinds of tying and bundling can be problematic. This may also have impacts on consumers or even small businesses for matter. And these are just 2-3 examples. What we thought when the Digital Competition Bill was being discussed, and this is not us saying, we had extensive consultations with stakeholders, and that is what they said, that there is a need for more evidence-based research from the Indian perspective before something is formulated, and more stakeholder discussions to make a particular regulation which is enforceable, because in the Indian context, the enforceability is also something which is important. So it is complex. There is no correct answer, but I think also realizing how markets work and the digital market is working is also important. Today, like, for example, Sharad was speaking about the data privacy regulation, which we have, the DPDP Act. It is great, it is India-centric, but while the rules are being made, concerns are coming, because, if you're talking about large language models, etc., they need data to work. The provisions which are given on anonymized data or consent, etc., there is a tension. And currently, the regulators is trying to envisage how they would be addressing those issues. So, on one hand, at one point of time, we may think it is great, but then some new things come in which was not envisaged. So I think that's a tricky challenge which is going on in this ever-evolving digital landscape. So these were some of the points which I thought I would share. And Anupam, what, the cases which you shared and what we think were important is, from the cases which you kind of highlighted when you actually mentioned about the Google, Meta, WhatsApp cases, etc. I think one is it shifted the views, the narrow market views, to a more holistic platform analysis view. Like, for example, CCOI moved from treating search or apps as discrete markets to recognizing interlinked, multi-sided ecosystems where you have users, advertisers, developers, or even OEMs, original equipment manufacturers. Similarly, it increased the scrutiny of big tech practices like the orders of Google, Meta, and WhatsApp, which showed the willingness to tackle with global players with record penalties and far-reaching remedies. And it also kind of set a precedence for a template for platform governance. For example, regulating App Store, the Winzo and Google case, for example, or data use parity clauses, which influence both Indian startups as well as foreign players. And the convergence between privacy and competition, like it was earlier mentioned also that the WhatsApp case, marked a turning point in treating perhaps the exploitative privacy terms as abuse of dominance under the Competition Act. the industry compliance and litigation also came into much more focus, because each of this triggered more intense appeals, partial stays, some behavioral adjustments, which showed that CCI's influence. It showed CCI's enforcement, but also the challenges which we were mentioning on the enforceability part, and the policy spillover, because these cases actually fed directly into the digital competition bill discussions, or the ex ante regulations of gatekeepers, etc., which has been discussed. So I think it's pretty complex, but I think more evidence-based research would help. And Anupam, I think the students, with the students of MNLU, if you can come up with more research, because we need more evidence-based research from the Indian perspective. Because on one hand, we want to grow our SMEs, we want things to happen. And especially today, if you also want the Indian markets to kind of flourish, we do have big Indian players also. They would come into this remit. So do you want to grow the market? You want to grow, for example, we want it to use AI in a way. We want the startups to use, they need data, etc. How do you go about it? You just can't shut it for someone for the other. These are complex questions. Yes, we do have geopolitics playing, and I think some of the examples which were shared, even in Korea, it is geopolitics which is stopping them, or even in Japan. Europe has also been criticized a lot by US about the DMA. While we do see some agreements which has happened recently, I was just reading yesterday on, of course, that's on trade framework agreement on reciprocal, fair and balanced trade. We don't know what kind of negotiations US may want for the US American companies in terms of competition with Europe. So I think everywhere we are seeing geopolitics play. Yeah, as in those are important, but there are other things of how do you grow your in domestic markets is not only a competition issue. What incentives you give in the Indian context, I would also like to clarify. For example, there is a lot of, for startups to work, there is a lot of compliance burdens. So are we easing those? As in, we should not use competition to address something else. There are other issues which to nurture the startups or to have domestic businesses doing better. There are other issues which needs to be addressed, and everything doesn't lead through competition. But yes, competition is important, but we should know where to segregate the issues. And I'll end it here, Anupam.
Thank you so much for the practical insights. I feel hindsight is usually the lack of foresight, and that's what is happening with the digital competition bill. Why we want to, take it back, but at the same time, it's good to realize that we didn't have a foresight, and we'd like to do some salvaging over there for our industry. But still, the road to digital competition law seems to be long and winding, and jurisprudence also in courts we don't see how visibility into some consistency or some visibility into how the jurisprudence is going to pan out. So I think it'll be a good debate for all of us on this panel to raise few questions. It will also help the students to, do the research on the gaps that you all see as panelists. So for the next, if everybody is agreeable, 25 or 30 minutes, we have time to do a discussion, a debate, and interaction amongst us. We also have some special invitees who may have some questions for the global experts that we have on our panel today. So I open the floor for raising few questions that arise from our conversation today.
Anupam, if I may, I actually have a question, and this is something which I have been thinking, and I think one of the speakers also mentioned. The issue is big tech. Like for example, we kind of keep track.
we try to see what is happening, and we see that, there is a lot of penalty they are bearing in many places, etc., etc. It's going on recently, even in Australia, they their competition found, there was Google to have abused their, etc. And they have been having fines, but that's not deterred the market, right? So even if they are penalized, even if there are, they found to kind of have been violated, the penalties are not working. So what is it which would work to get a more fair market? And that's a question, which comes up. We have regulations, and they're penalized for competition or privacy or etc.
But they calculate like cost and benefit analysis.
Yeah. So, but what's happened? It's not stopping them from anything.
I guess it's a very, very, very pertinent question. And sometimes you wonder whether the general counsels or the CEOs of these big platforms, whether they find any deterrence in this. So I guess everybody's perspective is going to be good to hear.
Maybe I start a bit. Ms. Vesalia, the commissioner, once said, in antitrust, we are in the business of deterrence. And so far, that hasn't always worked out. I mean, some of the fines were large, but if you compare them, then obviously with the gains from the abuse over the periods of infringement, they were a drop in the ocean. So they had no deterrent effects. Now, there are several ways you can deal with it. You could say then we need different remedies or sanctions that led to the debate of structural remedies, where just behavioral, a slap on the hand doesn't suffice. You can increase the penalties as such, or you consider also this sort of private enforcement angle, the damages that will and may follow from that. So it would be very easy, for instance, for authorities to give a bit of a helping hand to the victims by specifying in their prohibition decisions what the damage is and who are the victims, and make private enforcement generally easier. Then the risk of damages, and in the US we talk about triple damages, is creating an additional deterrent. I don't think that's the original purpose of it, but if the fines the authorities may impose don't have any impact, then at least private enforcement should do something, and the authorities could strengthen that angle through their own activities.
Odi, you wanted to say something, and then Amber also wants to respond.
Thank you very much, Anupam. It was quite interestingly earlier when Mr. Sharma spoke regarding engagements between the EU and himself, and why the EU would be backtracking on some of the measures that they have imposed. I'm not sure whether Mr. Sharma is still part of the discussion. But that was quite interesting to understand what is the EU's concerns with the whole with the measures that they have imposed. Thomas, I'm not sure whether you have some insight into that. Otherwise, it's just a curiosity.
Okay. Amber, you would like to?
Yeah. Thanks, Anupam. So a quick answer to Amrita's question, and then a question of my own as well. Not an answer as much, but a thought really. I always wonder if fines can ever work in isolation. If they have to be part of for lack of a better word, an ecosystem of solutions that we present. I mean, for me, I think what India and South Asia generally lacks is what we call a competition culture. We come from a culture of cooperation, and we don't understand why we should be competing with each other, and why our people are enemies, and why can't we share this information. So I think the advocacy function is to me a critical component of bringing about the change that Amrita doesn't see happening on the ground. And I must say CCI has engaged in advocacy function. What I think overall would be very useful is benchmarking advocacy functions and really understanding what they're linking to. Are we just going to schools and making, I see a lot of that, going to universities and making speeches about what competition is. But I think more targeted advocacy approaches with government, which they do undertake, but even more so. And I think that in tandem with fines, and I think that is something that Standing Committee on Finance is actually making that point now with the DCB. So I think, yeah, that kind of a sort of a multi-pronged approach would be more effective than just thinking of fines as deterrence. I mean, may not work alone, as hasn't worked, as Amrita pointed out. So, question of my own, and is it? I wondered about this in relation to competition legislation as well for South Asia and for developing countries generally. That is it worth starting small? And this is something that I've been thinking a lot about when I'm looking at other Asian regimes. They're not trying to do the big DMA style. I mean, they're doing DMA style in the sense that it's ex ante, but they're not trying to do a holistically, all-encompassing kind of a legislation. So I think that's a thought I have, that, is it important to recognize the sectors that you want to actually target and then go into, and that will also help create the culture, the point that I'm trying to make on the other side. So yeah, that's my...
I think definitely think it's going to be very helpful if we go sector specific, and Singapore has done that to quite an extent. I think amongst Asia, I only find Singapore doing that, to come up with special legislations relating to different types of platforms. So that is one. And one more thought I got from Amrita's question is that, remember when we used to get those antivirus softwares, how to Microsoft and the other. So in India, they were pretty expensive. And that's when, there was a lot of piracy happening. So, people would not want to buy the entire, the original one. They would just have a, copy of it, and then you could freely use it at just dirt cheap rates. So, but after that, they have reduced the price of, that antivirus to quite an extent, like less than half. And now there's hardly any, because people want to, they want to use original, they want to, comply. It's just that when it becomes difficult, or when it's too costly, people don't, get down to complying. So I feel if, regulation is more about obligations, more about, transparency, and just, not very harsh, then maybe it will be easier for them to comply. And just like in cartels also, when we found it so difficult to find cartels, there was leniency that helped into, getting some information and getting people to own up. And we had whistleblowers who could benefit from disclosures. So maybe that's also another thought to it, that not anyways the penalty is not hurting them. So how do we make it easier for them to comply and incentivize, more than, so the advocacy helps them incentivize, and more aware consumer will also if there's advocacy and the consumer is also more aware, then they want to work for the consumer. So I guess that's also a big incentive.
Anupam, if I may kind of come in, for example, in the WhatsApp and the Facebook WhatsApp merger. Okay, now as a user, I do understand that there is data sharing which happened. It happened even before my consent was taken. But as Shilpi was mentioning, I want to use that platform irrespective of that, because I don't have an alternative of a platform of that kind. That's why I'm using. I know my data is being used. Even today, I use Google Map whenever I'm going anywhere. I know it's tracking me completely, but I'm using it because it gives me the convenience. So for a user, the balance between convenience and what you are giving away, it depends upon people to people. If you have an alternative, then people will move to it. And I'm talking about consumers. But if there is no alternative, people are not shying away, unfortunately, from giving their data or using that platform. So that's also the challenge here, as in this entire story. And I would take myself as an example out here first.
Very true. That's where behavioral science comes in. That the consumer is not crying. The consumer is happy to share the data most of the times. It's only when they are aware that privacy concerns, some of them, or maybe there's just a lobby that
or when the repercussions are very high, when they're using, no one's kind of understanding, but it's a long-term effect when you understand how you are, everything's going on.
Yes, Shilpi, you have something to say.
Thanks, Anupam. So just on the remedies point, my thoughts are I see in a lot of the digital market cases that the CCI is now also offering sort of a bundle of remedies in addition to penalties. So they're also recognizing that penalties are not going to fix the problem. You need to remedy the problem, and a lot of these are behavioral remedies. So we see in the WhatsApp case, for instance, that there's like I mentioned when I was speaking, that they're also saying that, clarify to consumers what kind of data you're collecting and why you're collecting that. So it's not just about penalties, but we also see non-compliance, not just with payment of penalties, but also with the other remedies that the CCI is suggesting. So there's just systemic non-compliance. And this is very clear in the Google Play billing case, the Google Play billing system, that case, where the CCI said, you shouldn't charge this much, you shouldn't charge such high commissions. And then there's now a subsequent case brought to the CCI that this compliance of Google's with this order is creating is not real compliance. So the user choice billing system that they've introduced is actually not compliance with the Google order. So the proposed compliance the compliance that is being proposed is actually creating more competition law harms. And I think also sort of Thomas mentioned that when he was talking. So I think we do, and that's what I was trying to say, we do need to think about remedies more carefully and more critically. The settlement and commitment mechanism allows us to do that. So at least for those kind of cases, you don't have to focus on like what is the problem, but focus on the solutions. And at least we need to focus equally on the solutions and the problem, because if you're not focusing on solutions, I think the DMA also allows you to do that. Because there is a systemic culture of non-compliance that we need to overcome. And this is a very, very deep-rooted problem that we need to address very carefully. In India, we are not doing that. The other thing, just on Amrita's point, was it's not that we're using WhatsApp because we want to use WhatsApp. It's because we don't have a choice. There's no other equivalent communication system that we can use. I have tried to move to Signal. No one moves to Signal with me. So I have to be on WhatsApp. So my consumer welfare is being reduced because of the power of network effects. But other than that, the biggest problem is that consumers do not understand the gravity of the costs that they face when they deal with digital markets. There is a lack of understanding of what you're giving up, because it's not money. It's a lot more of nuance. So because you don't understand what is the significance of what you're paying, because it's not money, you cannot then make an informed decision. And that is why the market needs correction, because there is a complete lack of information about how these business models are working. So and then I just had one question, which was sort of, we keep saying that sort of Indian markets are different and therefore they require a different approach. But my question is, in what ways are they different? Because we do see that a lot of the cases against big tech that are brought in Indian markets are brought by small and medium-sized enterprises. For instance, the recent Kirana store complaint with respect to quick commerce companies, The Google Play case I was mentioning was brought by a bunch of app stores. So we do see small and medium sized enterprises are adversely impacted. They're the ones who are really trying to fight against big tech. So what is different about Indian markets? I really want us to dig into that. And also, we need to understand what we want from digital markets. It shouldn't be that, oh, right now big tech is great, but because there's a lot of kind of narrative around this, we need to think about what is it that we want from our markets, right? What is it that we want to see in our markets, and not just look at what is happening right now, but we have to have some creativity and vision and an idea of what would a very competitive space look like. And we should base our regulatory efforts on that, not on what's happening right now, but on what is our vision for the future.
That's a very interesting point, Shilpi. From the Indian perspective, my take on this is that there is always going to be tension, and we have seen when it comes to traditional taxi, traditional market, which is the Kirana stores that Shilpi is talking about, and the technology markets. So the point is that when inefficient players or old and traditional players are upset with new technology coming in, they want to they want to disrupt that market when they are getting disrupted. So they want to what they can do is just go and put a spoke through cases against them, because again they create a narrative. But competition law talks about allowing efficiency in the market, allowing efficient players. If the consumers using cab apps and not traditional taxi, the consumers using Amazon or any other platform, e-commerce, quick commerce, as opposed to the traditional market, then the market is choosing, and accordingly the players and whoever wins is going to stay in the market. Doesn't mean that we need to defend the inefficient players. Now coming to market distortions, we've learned the traditional competition law how we can find artificial barriers, and market distortions can be corrected by removing these artificial barriers. So I really wonder that by ex ante rules, can we really minimize these market barriers, or these market distortions be minimized by stringent rules, or by putting rules against structures or structural changes? Because we just spoke about how there are behavioral changes which can be recommended. So
And yeah, I just want to as in, this is my take, and the Indian market as I see it is just not the startups who are coming up in the e-commerce space, or even the kirana shops, etc. There are also smaller businesses. There are women who make handicraft and sell it online through some platforms, etc. This is helping their business. I'm not saying good, bad, these exploiting, but this is creating opportunity. That is also Indian business. So are we giving that kind of an opportunity? And as Anupam was mentioning, the cases of kirana, shops, proper shops, having a case with the quick commerce companies, etc. For an individual user, it is also a matter of choice. It is convenient to me to go online and buy it in an easy manner. Rather than walking and going to a shop and buying. So it is, as Anupam was saying, I think it's a disruption also which is affecting them, that this is disrupting their existing traditional business, harming their revenues, etc. Another interesting thing which we have observed, and I will not name which case and not name it, there was a particular case by some companies against a big tech, etc. After, things were settled with CCI, etc. The actual companies who had raised this issue were okay because certain things were okay with them, and then they said, okay, we should give a pro submission, etc. So that also happens. It's sometimes a business issue also. So it's not a very, as I said, black and white thing. Whereas we may see that Indian startups are, putting a case against this because of market behavior. But as soon as their interest is met, absolutely okay, there is no issue. So that also happens. So it's very tricky, this entire thing. But yes, there are market effects, as in definitely the power of big tech is a thing. But when I look at the industry, if I look at Indian industry, it's not just the big players or the smaller ones. There are absolutely, village level entrepreneurs also who want to do business. And these big platforms give them an opportunity. They may be exploited also, their margins might not be good, but they get a market which they would not have got. And there is no other way they would have got it, because they're not getting that kind of platform. So that's there. And if we say the Indian market is unique, it is in some ways unique because we are price conscious. Like, for example, what Anupam mentioned, it costs us. We are not that rich. Even today, most people use Windows or Microsoft without license. When toothpaste started being sold, even today, they are the sachets which sell more in the villages than the tubes, because people can pay and use. If you look at the telecom, the tariffs, initially, which was there, the recharge starts from 100 rupees. It's not 1,000 rupees, because people recharge, they use, and then they finish it off. And when they have money, they use. So if you look at India per se, not everyone is rich, not everyone is middle class. So the buying behavior, the consuming behavior is different. And that's where we normally say that even when businesses come into India, they have to change their strategies a bit for this market, because it's huge, but it is price conscious. We don't have money. And I think that goes with even African countries, etc., many of them. So that's where we say it's different from a European market or a US market. Certain things may be similar, but there are dissimilarities.
A lot of socio-political issues are very similar because of these, small businesses and disorganized sector. Yes, I do tend to agree. So, yes, somebody...
Very quickly just throw out a phrase, really. I think the information asymmetry is much deeper in, for instance, India or even some African countries. So I think it's we place so much onus on a consumer choosing, and there's always an asymmetry between the business and the consumer. But I think it gets deeper with a lot of the sociological issues that we are pointing out. That asymmetry gets deeper. I quickly also want to talk about sustainability in Europe, for instance, which was nobody wanted to talk about it 5 years ago, because competition and sustainability belong to two different planets, perhaps. But I think very careful information sharing and sustained information sharing, making consumers understand the true cost of their choices. So it's not, we are price conscious. I mean, I'm South Asian as well. Of course, we are price conscious. We're not as rich as Europe, but we are also conscious about other things. And I think the reason we're not able to exercise that consciousness is because we are not aware. So I think that is something that we need to add to the fray as well, of the factors to take into consideration.
So yes, that's very true. So we are in agreement there. But I'm still inquisitive, and I want to know it from my European friends, that will these ex-ante rules really minimize market distortions?
Maybe just to build on the point that was made about people being price conscious. Okay, so you have a platform like Apple, and Apple connects the consumer and the business. But if you have multiple platforms, each of which are competing to offer the business the best terms and conditions, prices will go down. So the problem with a monopoly e-commerce platform is that it will necessarily want to take as much rents as possible. So I think the idea of asymmetrically regulating the dominant player is to create space for other players to compete against it. That's what contestability is about. And then you can have more innovation. So, if price is the thing, then competition is that which reduces price. We know that from economics. The other point I wanted to make just briefly is about choice. You've all talked a little bit about the consumer needing to make choices. So maybe this is a little bit out of the wall, but another very complex product that people buy is health insurance. So in the United States, you renew your health insurance once a year, and the date for renewal is Thanksgiving. Why? Because Thanksgiving is when the family gathers. And so the younger generation can inform their parents about which health insurance plan is best for them, because they have a comparative advantage. So you have a choice moment where everybody in the United States is making the same choice about which health insurance to buy. And because the information is very complicated to process, by creating a moment where everybody is deeply engaged into making that choice, then people are able to make better choices. So the question is, can we translate that somehow to the digital environment? So, at the moment, people are given choice screens left, right, and center, but there isn't a concentrated choice moment where people are reflecting on the implications of using Chrome instead of Opera, or, as Amber said, in terms of sustainability. Where is that choice moment that builds consciousness? And maybe that's something we could think about.
Thank you. Just Anupam, on your question regarding the ex-ante approach, something that was striking me was in the South African market inquiry that some of the firms start out to be vertically integrated. It's basically their model. Or they start out to, for example, be a seller of books. We initially had Kalahari.com, and they only sold books online. Takealot bought them. Takealot were also selling books. So suddenly Takealot started to allow other people on its platform. Now, if Takealot is not allowed to self-deal or self-preference to some extent initially, then it will have difficulty in making that transition into becoming a type of an organization that makes some kind of a profit in the initial stages. For example, now Takealot must divest for all practical purposes the two aspects of the business. The one is marketplace and the one is retail. So I'm just thinking how, if there was a rule in place regarding self-preferencing, how would that situation have developed? Because many times, also due to resource constraints, small businesses start out doing more than one thing, covering more than one part of the supply chain. So that is perhaps also something to consider.
Thomas, you want to add something about ex-ante rules minimizing market distortions?
Yeah, I think your question, the original, was regarding the capability to bring down barriers to entry. And I think there can hardly be a question about it. The DMA describes how these obligations increase contestability, which is another word for bringing down barriers to entry. Just take the examples of those obligations aiming to create some platform-to-platform competition in the search area, with data sharing obligations, choice screen obligations, so that small market entrants are enabled to catch up, and some of the current maybe insurmountable barriers to entry are kind of broken down, and the moat around those core platforms is kind of destroyed, so that really challengers have a chance to catch up. So I think there's a lot in the Digital Markets Act that really tries to bring down those barriers to entry. But even when it comes to small companies that don't even want to compete with the platform, if you make sure that the price they have to pay for being on a platform and being found on a platform is not going through the roof through auction-based advertising systems, for instance, but you have more of a control also on pricing, then obviously you also reduce the costs for those new market entrants, and that will benefit the economy as such. So there are many elements in ex-ante regulation that will bring down barriers to entry.
The parameters for fairness and contestability are not really standardized, are they?
Well, firstly, you shouldn't be too confused with the terminology. One of the reasons why the EU went for contestability and fairness was also to distinguish the regulation from the primary European law on Article 101 and 102. So not to confuse it with the strict kind of barriers of competition law. It had to be something different. So therefore, new terminology had to come up. But this doesn't mean that general learnings from competition law can't find their way into the DMA. And contestability has been an established concept, in particular in network industries, where over the years the issue came up. How do you regulate incumbents so that their advantages from being there all the time come down? And there, this contestability idea came up, and I think it's a sophisticated enough concept to serve as a general kind of guidance, but certainly as such, this is not kind of a legal parameter. It's more the idea behind it, and you need to fine tune the obligations following from that.
Sure, thank you for that. Any closing remarks? We can all just have quick closing remarks, maybe. Or unless there is something more to. There's no end to this discussion, though.
If I can just quickly say something, I'm not sure whether India has a Futures Institute. In South Africa, we have the Futures Research Institute, the IFR, and that might also be a good organization to involve. They use methods that are rigorous from a quantitative perspective, but also from a qualitative perspective, looking at different trends from different perspectives and interpreting that for purposes of various different futures. So that's perhaps also something that one can consider going forward as part of this discussion.
Surely, I think our competition commission definitely needs to consult a Futures Institute, because they still haven't incorporated Gen AI or even AI into the core services, the core services that were defined as anti-competitive practices. Shilpi, you want to say something in the closing?
Sure, thanks, Anupam. So I saw there's a question about what's going to happen now that we don't have a DCB. Maybe I could just close addressing that, which is, I think we'll just go back to how things were, which is the Competition Act will try to do its magic. The CCI is pursuing a number of different cases in a number of different areas, including sort of news media. We're waiting for the Amazon case, et cetera, et cetera. So there are a number of areas where we hope we will see enforcement, but that process is going to be really slow. And I don't expect there to be much change in terms of the way we see markets functioning. So I think overall we need to have more of these kind of discussions would be where differing opinions and differing expertise can come together, and we can sort of look at what we really need. I personally think that with the standing committee report, it is now clear that we do need some form of regulation. The question is what form, and that's the question we need to focus on. How do we regulate effectively? How do we prevent overregulation? How do we understand what India really needs in terms of regulation? And this requires a much more sort of a nuanced view. I don't think it is correct to say that these markets are perfect and don't need any regulation. I think that's a very simplistic point of view. So I think we have to move away from that.
Anupam, if I may add, while the DCB has been taken back, I do hear, and this is just grapevine, which is saying that there are still some discussions going on how to kind of tackle these issues. So it's that bill or DCB may be dead, but there are still discussions because there is an issue. I think even the regulators are trying to decipher how to address it, because as Shilpi mentioned, the standing committee is also mentioned, as in there is an issue, but how to address, I think they are taking a more nuanced approach. And perhaps, Anupam, for the first time, CCI actually had stakeholders' comments in the, when the DCB was being discussed by MCA. I think having a more wider discussion with stakeholders, not limiting, as even Amber was mentioning, in the colleges or certain big tech platforms or Indian companies, but also to academics, civil society, etc., to get a range of views, as in they need to expand their horizon, as Amber was mentioning, to get the views so that they can come up with something which is more nuanced. Also, I'm sure they're doing in research, but, there should be more encouragement for people to do research, like you all are doing with the MNLU, etc., so that there is more, as in they should encourage this ecosystem to come back with more information, and it should not be just those who I know I will call and discuss. And the processes of the consultation should be more extensive and transparent, like, okay, these many people submitted the views, this is how it is. And in that, I would say the telecom regulator actually does a good thing. Whatever, if they come up with a consultation, they post the, who all have submitted comments or counter comments, etc., irrespective of what they do at the end. But at least that part is, they need to involve all stakeholders.
You need to read the comments also.
Yes. And you also have to involve the technologists, because, many things which for legal or us may sound very easy, technical community will actually say whether it works or not, or this is the solution. The technical community is never involved, engaged in these things. I think involving all stakeholders and having truly multi-stakeholder discussions is important, and also intergovernmental discussion, else the turf war between the departments come in later.
Very true, very true. Amber, yes.
Yes, this reminded me of something which I absolutely have to share because you'll all know it. But I want to start by saying that this is definitely, for me, as an outside observer, a moment of opportunity for India to do a brilliant act, right? There's no point in having a DCB which won't work. And the story I want to quickly tell you, and you'll all know this anyway, of course, is that India enacted the Competition Act in 2002 after 2 years of, the Raghavan committee slogging away, talking to everybody, but still quite closed door. And then, it didn't do anything. I mean, the commission was established in 2003, and then for the next till 2009, nothing happened. But what did happen in that time is that the act got better. And it got better precisely because people spoke up. I mean, it got better because Brahm Dutt, and some people said, oh, I don't know who he is, but I think he did a great service, because people said at that time when I was researching this for my PhD that he was motivated and somebody put him up to it. I don't care how he got there, but we got a better act. And the proof is in the pudding, because it has worked continuously. And, I think we also have to understand that this is a learning process. It's a trial and error. I mean, if anything I got from the Asian experience is that everybody's doing a trial and error. It's not India that is stuck in this, an unknown sort of no man's land, and everybody else has gotten it right. I mean, even EU, which sounds so sure-footed, is also finding its way through this space. So I think India has its own history to look back to, that, sometimes these seeming blips are moments of tremendous opportunity. And I mean, they're sparking this conversation, and the conversation is now taking place at a much more informed space than it was when the CDCL was formed, and they were talking to themselves, really, and looking at EU and Europe and UK, but without knowing how EU and UK would work. But now they do know how they would work. So I think we can have.
That's definitely a brilliant point that you've taken out. Very profound, in fact, that how, this is actually a point where inflection point, we can look at a brighter side. And what Brahmadat really brought about was a judicial appellate body, which did not exist when the CCI was conceptualized. Very true. Professor Monty, would you like to give your closing remarks, and especially about something about consultation, some lessons from EU, if we can take?
Sure. I mean, maybe one more general remark before lessons from the EU. In listening to all the contributions, we are looking at very similar industries in very similar ways. So to a certain extent, one should perhaps build this into some sort of conversation about, we know in certain instances what needs to be done. and we can maybe learn from each other. So once one gatekeeper or one firm has been regulated in a particular way, and that behavior is basically replicated across the globe, reinventing the wheel and running the case again and again and again with the same arguments can be a little bit problematic, or maybe just using the evidence that's already been obtained that in one jurisdiction to another. So some sort of free movement of decisions and some more collaboration could perhaps enhance also the deterrent effect. But I agree with what Amber's just said. Even with the DMA, we're still learning how it works. There were expectations about how it worked, which were not met. And so the question is, how do you make the most of the legislation and how do you secure compliance? And maybe one final remark would be, in terms of deterrence is always tricky, but maybe using mechanisms that encourage the regulated firm to behave in a pro-competitive manner, which is also profit maximizing, could be the way forward. So to try to push them away from not competing and towards competition. So in telecoms, that worked to a certain extent. Even the incumbents were forced to innovate. And so creating a regulatory space for the regulated firm to compete may be something to think about.
Great. Thomas, you have something to add, please?
No, I fully agree with what Professor Manti just said. So, and I also think that the differences between India and Europe are not that significant in this respect. I mean, everyone wants to save money. It's not just an Indian thing. And I would say the more need there is to look for the penny, the more need there is to have a proper regulation that keeps prices down. So I don't think that is something that should speak against an ex-ante regime.
No, certainly there's lots to learn from any developed jurisdiction. So EU is something is still learning, but at the same time, with so much experience, I think we are at a point where we can have best of both the worlds. We are new, but we can still learn. So even from the pitfalls, one can learn so much. And yes, everybody wants to save money. That's for sure. So really, this seems like such a amazing room of so much of brainstorming, and it's sad that it's going to end. But it'll be great to continue these kind of discussions and deliberations. I'm sure the students have taken so much from here, and thanks, Professor Monty, for your comments for the students on the chat, and very helpful for them. And we'll get down to our research soon after this session. We have 3 prize winners who are waiting for their certificates. We had a challenge. We had a competition on articles relating to the digital competition bill, and 3 of them have won their prizes. So we'll quickly get these prizes and then close. May we have the certificates displayed for?
Yes, ma'am. I now invite Ms. Asta Tiwari ma'am from MNLU to kindly come forward and distribute the certificates for the article writing competition of the TechRec Forum. Ma'am's guidance and contribution in the field of law have been truly inspiring. We're also delighted to share that the winning articles will be published on the TechRec Forum platform, giving due recognition to the efforts and insights of our participants.
Thank you, Rachna. Ritesh, can we have a copy of those certificates on the screen, please? So the winners are Medhavi Verma, Krishvi Reddy, Dia Sinha. Congratulations, all 3 of you. I wish you keep writing, and today's discussion was such an important discussion. So it clearly shows that if we have to embark on a journey, it may look like an unfamiliar terrain, just like digital competition bill looks to us, but then it's a very important journey to travel. So all the very best, and I wish you all the luck. I also want to thank all our panelists. A special thank to Professor Monty, who graciously agreed to be our guest of honor at such a short notice. It was such a profound discussion from Dr. Shilpi, Dr. Hopner, Dr. Amber, Miss Udi, Amrita ma'am, And definitely, I agree with Amrita ma'am on one point that we need to have such consultations more often. We need to speak up. We need to have a multi-stakeholder consultation. And it's very important to have people from all walks of life to talk about this particular topic, even if it is related to them directly or indirectly. So thank you so much. Anupam ma'am also, I think she initiated this idea when we met at MNLU. We were just a bunch of researchers, working on different subject matters. But when we sat together, we realized that this is the most important thing to do right now. And we have embarked our journey. This is our first step of our three-step lecture series. So this was the most important step. And I think, ma'am, we finished, I won't say we finished it, but we started it quite well. And we will need your support in future, everyone. So thank you so much for joining us today. And thank you so much, Anupam ma'am.
Truly grateful for all of you and the contribution you all made. Thank you so much. Asta, you may want to get the three winners on video if they
Yes, I will just add them. Wait, are they added? I'll just
they can just have a word, quick word.
Yes.
Anupam, and maybe just before we congratulate them, I also want to congratulate India, because I think in some of these cases you actually took the lead. Wasn't it in the App Store's case that India was actually the first to bring that digital case? And I actually followed that quite closely, because in that time our business started with a Betweenity app. So that was very relevant for small business in South Africa, what's happening in India. So you can trust your instinct. And thank you for the lead that you have taken for the rest of the world. Thank you for that.
And one more thing, there's Professor Kani from Malaysia. If she also wants to come and say something, because she was specially invited to, she put the questions on chat, but if she wants to say something, we can get her on video. Professor Kani from Malaysia.
Ma'am, just give me 1 second. I'll just add her to the panelist. Miss Kani, are you able to join? Okay, yes.
Nice to see you.
Hi.
Very nice to see you.
Hello, hi.
Thanks for joining. Very nice to see you.
Good afternoon. Oh, it was such an interesting talk today. I've been following from the beginning. Of course, in between I had other engagement. But I think as an observer, all right, I represent, I'm from Malaysia. So my research is mostly focused on ASEAN. So I think there was a lot of lesson, lots of contribution, lots of sharing that that I got today, all right, which I could learn in my research, which I'm working on the digital market management, because we haven't gone into the act yet. In ASEAN, I think some of the ASEAN members have already have been affected by the Brussels effect. It's more of so what I realized it was very interesting to hear the different aspects, especially from Amrita, from the practical, from the legal, non-legal, as well as from the economic perspective. And what I realized that as an observation, the DMA is it's not just about geopolitical effect, in the sense that it's not that everyone has to have or not to have. Okay, but I think it has to go down to also looking into the political economy of the each member of the states when they are trying to adapt. So I think there's lots more research must be done, lot more like suggested there should be engagement done with the civil society stakeholders to see actually how it's going to affect. Because one of the criticism which was pointed out with regards to the observation that they made on one of the reports in EU on the DMA is it has an impact on the incentives to innovate. And innovation from the digital economy is very important for Asian countries, especially because our small traders, SMEs benefited from that. So that's why we have like to say that sometimes you have no choice. Okay, you know you are compromising your data, you know you're compromising certain of your aspects that you do not want to. But then again, like we have in Malaysia, Indonesia, they're very dependable on this digital economy, especially the small traders, because they market. Otherwise, they couldn't have gone out of it. They market through the WhatsApp, using Facebook and all these things. So that's why we are a little bit slow in trying to regulate it. Because one thing which is very clear, when the European EU's DMA came, they were very clear. The objective was very clear. They know who they targeted. They know who they wanted to capture. And also they made it very, they wanted more of a preventive ex ante, so in the sense that they want certain obligation and they want it targeted for that. I think the similar way should be approached when it comes to Asia, similarly to India. And I think India, you have a lot of similarity with you, because you have lots of these issues with these digital marketing companies and the digital platforms, because they're to the ASEAN nations. We have more of a user than, you know, being the startup. We don't have so many startup. We are the users, and we depend so much on that. That's why our governments are very slow in trying to regulate it, because our dependency level is really high. So we have no choice. But then again, as I come back to the general observation that I made, I think it should be geopolitical as well as coming down.
Anupam ma'am, you're on mute.
Yeah, can we have Krishiv, Medhavi, and Dia on? We lost you.
Oh, lost.
We lost, but now you're back. Yeah.
I was just saying, my last point is like, when we are talking about adapting the Brussels EU law, I mean, we there's no choice. We have to, end of the day, regulate it. So digital market regulation is essential, but it should be geopolitical as well as taking into political economy of each country. Before, there must be a lot of study done. Of course, the understanding and the advocacy level, as Amber pointed out, the culture of competition is not something of ours. I mean, we are looking at EU and US, which has a history, you know. So this is an evolution. We adapted. So in the sense that there is a lot of cooperation, there's a lot of collaboration, there's a lot of like engagement of the government, engagement with regards to certain markets. So domination is there. So we need to balance it. We need to have the right balance so that the impact will not be too stressful or strainful on our local traders, especially our small traders, SMEs, local champions. They're not necessarily SMEs, but they're local champions. And they are actually revenue for the country. I mean, they provide employment, so we still need them. We do not want to mark them down. So I think there's a lots of, as I mentioned earlier, engagement must be done, and more discussion like this, so that it's an eye opener for us to see how we can improve and how we can actually learn from each other, especially Asian, because we share the similar kind of a political economy, you know, where price is concerned. You have to take into account more of those kind of things. Thank you, Anupam. Thank you. It was very interesting engagement. Thank you for all the speakers.
Thank you. And Krishiv and Medhavi, would you like to come on video and say something? Are you more inspired to write?
Yes, ma'am.
Yes, ma'am. This was a very interesting session. And, you know, it definitely kind of inspired us more to read about this aspect of the
If it was
law
so
and
interesting, let the others see all how, you know, we see your faces, so they see that how interesting it was for you.
I'm actually in college right now, so I'm just going for the class. But it was definitely a very interesting process also, you know, writing that article, because I remember I was in my first year, so I had no knowledge of that subject also. So even researching and, getting to know so much new information was very interesting. And I'm very excited to, learn more and stay curious.
Great. Thank you. Krishan, you want to say something?
Yes, ma'am. It was really very insightful and engaging, and I really enjoyed listening to the conversations and being able to listen to so many esteemed speakers. And I'm happy to be a part of this again. And writing the article was really fun and researching about it. And uh, I want to continue researching on it further too. And I'm really grateful for the opportunity to attend this again. Thank you so much.
Thank you. Shall we close?
We'll close, ma'am. Thank you, everyone, once again. Thank you, Anupam, ma'am.
Thank you so much. Bye, everyone.
Thank you. Take care.